And my lord, one more indulgence I seek your favor. One item which was listed on my lord 21 8 2025. You know, we are there for 2 weeks. My lord, 2021 matter may come for admission money, yet to be admitted.
Admission
Yes.
in January.
My lord, can it be 11th of December, my lord?
No, but 11th is.
Thursday.
You can have it on 12th.
My lord?
12th. 12th December.
Yes.
Yes.
Wait, please, my lord. Prayer for listing of a motion matter for Friday, my lord.
When was it filed?
Filed on 27th of November, not been listed, not been registered till date.
On Friday.
I'm deeply obliged.
May I please your lordship, I beg to mention for listing intended to the application for stay vacating of interim order on
For-
Monday. For interim order, lordship.
Oh,
Lordship, what happened?
for admission,
Order, lordship,
for orders.
for Monday, lordship.
Monday,
Yes, lordship.
8th.
8th, lordship.
Listen, I beg to mention for listing, my lord. That's the admission matter, my lord. That before vacation, any date,
Why before vacation? Come, you want an admission hearing?
the admission hearing, my lord, with the challenge is the selection and appointment, my lord. Already 2 years gone. Any date before vacation.
Any date, we have no dates to give you in December, or everything, all the dockets are filled up. If you can have it in January, we can give you in the first week only, immediately after reopening.
Okay, my lord.
On 8th of January, 8th of January.
Hmm.
26.
Please, your lordship, I beg to mention bench 3 matter for listing on 9th. Your lordship, connected matters are listed on 9th and may be tagged along with it.
What is that matter?
You know, it is regarding the appointment in Assam Police. So yesterday the matters were next listed on 9th. So maybe tagged along with it.
Where was it listed on 9? When is it fixed on 9?
Yesterday the similar matters had come up before court 15.
So you mentioned it before that court?
This is the senior bench.
All right. Is it part heard before that court?
No, your fresh matter.
Fresh matter.
Fresh matter. But
Fresh matter, you let it come for motion.
But similar case, this it should be connected.
Those matters are listed for motion or admission.
Admission.
Then in your fresh matter, you'll have to issue notice. When did you file it?
Yesterday.
Yesterday. So you wait. By 8, if it doesn't come, you mention it. Yes.
May I please, lordship? Lordship, I beg to mention 2 writ petition, lordship, which were filed on Monday, lordship, maybe come up on Friday.
Friday.
Yes,
Fresh matter.
yes, lordship.
All right.
My pleasure, lordship. Praying for withdrawal, my lordship, or with petition.
Withdrawal.
Withdrawal.
Tomorrow.
With the liberty to file fresh, the new cause of action.
Matter has to be listed first.
Yes.
Tomorrow.
Yes.
Yes.
Okay.
Lord, fresh matter, my lord, for Friday, my lord.
Friday.
Yes, my lord.
Let it be on Monday.
No, my lord, because my lord, urgency is that, my lord.
When did you file it?
It my lord, yesterday filed, my lord.
Yesterday filed.
Yesterday
it will come
filed.
on Monday.
Because, my lord, what has happened, last date is 9, my lord. Constable group GD, my lord.
All right. Fifth. Yes.
May please, your lordship. I beg to mention listing of an IA, lordship. It was filed yesterday.
IA in what matter?
IA in lordship, matter is pending before your lordship regarding promotion.
Promotion matter.
So, lordship, I have filed an IA for early hearing. Lordship, because it has come on several occasions, but due to
All
paucity
right. Let it come on 10th.
obliged.
With the consent of the other side, your lordship, I'd like to mention item number 32. It may be listed on 10th, your lordship. The other side has no problem on 10th.
32.
Yes, lordship.
Item 32 on the request made on behalf of what? Writ petitioner.
The writ petition.
Writ petitioner, opposite party in the IA. Matter stands deferred to be listed after 2 weeks. It is submitted. Consent of the counsel for the petitioner is also being stated. Yes.
Can it be on 10th, your lordship?
10th of December.
Yes, lordship.
No.
Otherwise, any date before 15, your lordship.
Let it be come in January.
But if they have the problem, other side, they have consented only for before 15.
But that consent is subject to orders of the court.
Any date, your lordship, before the vacation, your lordship.
Let it come on 7th of January. 7 January.
The other side will,
The other side we do not do.
they have said that it will
You
be
say
taken-
the court has fixed the matter. Yes.
May I please, your lordship, I beg to mention item number 29, my lord. Kindly pass over the matter for the day, my lord.
Item 29 on the request made by petitioner.
Petitioner, my lord, on behalf of NJ my lord. Youngest council.
This matter has been passed over for several days. Why?
My lord, the youngest council is facing some difficulties and the person who was youngest in this case, he is hospitalized. Actually,
Oh.
my lord.
Matter stands deferred to be listed after 2 weeks.
Obliged me.
May I please, lordship, I beg to mention item number 23 of daily list, my lord.
20?
23, my lord.
Oh.
I am for the respondent number 6, my lord. We have already concern of the other side, my lord. So my senior is now out of registration. So
Who is-
matter may be
have
picked
you
up.
have you informed the other side?
Yes, my lord.
23,
matter may be
the
fixed
request
after 2
made
weeks,
by
my lord.
council for the respondent number 6 with the consent of the council for petitioner stands deferred to be listed in the month of January on a date to be fixed by the registry. Obliged.
May I please, your lordship? Lordship, I beg to mention for listing on writ petition, lordship. The matter is regarding non-payment of pension to the petitioner, lordship. Can it be fixed on 8th of December, lordship?
10th of December.
8th, lordship.
10th.
Obliged. May I please, your lordship? I beg to mention for listing, lordship. There is a 2 writ petition. Any date, lordship?
Listing for what? Admission.
Admission, lordship.
Have it on 21st of January.
Yes.
item 1.
Yes.
Petitioner's husband, my lord, was in the panchayat, my lord, Jilla Parishad, my lord. He retired after, my lord, brother, he had 35 years of service, my lord.
Hmm.
My lord, he died in 2002.
No, why are you coming now?
My lord, this lady, my lord, she's the widow, my lord.
You
and
have
of
to
course,
explain the delay.
my lord,
Why-
we've explained,
why
my lord, we've explained, my lord, 2011, my lord, and my lord, these are pension matters, my lord.
No,
Only
pension
pers-
matters all right, but you have been sitting over it.
My lord, 2011, my lord,
Who enlightened the lady?
well,
The
2011,
High Court is giving orders.
2011,
High Court,
my lord, 2011,
74-year-old lady.
2011, this entire process started, my lord, long after her husband died, about 9 years. But thereafter
That's
she
what
got-
we are asking you. How did the lady come to know?
Well, a lady, my lord, she had approached the authorities, my lord.
Ah.
That's my lord. My lord, paragraph 18 and 19, my lord, explain, my lord. Then, my lord, paragraph 22, my lord.
No, these explanations are omnibus explanation. You have to come up with something concrete.
Lord, the-
You can't just, this can't be, this is like, as if we are doling out orders, inviting people to come to court. This is not
But you did, my lord,
what the courts are for.
my lord, the Honorable Apex Court has said, my lord, once similar persons are given relief, my lord, people should not come to the court. So these are pension matters.
Therefore, we are asking the respondent to find out why people are being forced to come to court. What steps have you taken?
Lordship, that would, other than that, Lordship, this delay has to be taken care of. There is no explanation. They only file a
No,
representation.
no. Once the court in Fazle Rabbi has given that, and subsequently there has been orders passed by this court, what has the department done?
Lordship, many
Should the department not take an action to find out who are the people who will be given the benefit under this Fazle Rabbi judgment?
Lordship, there are many persons who have approached the court without approaching
You
the
are
court.
not
Also, they have,
understanding the question. First, listen to the question. We are asking you, is it not incumbent on the department? Is it not the burden of the department to find out who amongst these former employees are entitled to the benefit? Once the court has given an order, it has to be applied to all. Why are you forcing people to come to court like this?
Lordship, they come to the court at the end of the hour. They file a representation only.
We are asking you a question, you are not giving us. If you can't give us, we will call your commissioner here. We will ask your commissioner, maybe she will have better information to give. Once an order is passed by the court, you have to do that exercise to find out who is affected, instead of forcing people to come to court. What stops you from doing it?
Things stops, Lordship, but this petition, the delay part has to be taken care of.
Delay part will be taken care of provided you give an explanation that the department has already taken steps.
It's, Lordship, it's not the case that
Learned Council for Parties, issue notice. Return over 4 weeks, Mr. A.K. Ghosh, APS for respondent number 1, 2, 3, 4.
2 and 5, I have.
1, 3, and 4, Mr. D. Bora for 2 and 5. Who is for 6?
So Lordship, 6.
Mr. Ghosh for 6. And Treasury Officer who for Finance?
Finance.
Mr. A. Choliha for Finance. The petitioner before this court submits that the pensionary benefit of her husband was
Recently. Oh,
not calculated in the manner as provided by this court by the judgment dated 24/3/2010 in writ appeal number 145 of 2009, which attained finality after the dismissal of the SLPs filed by the state. The petitioner's husband had rendered about 35 years, 1 month and 25 days of continuous service as a grade 3 employee under the Zilla Forfeiture. However, the respondents have deducted 19 years, 4 months, 2 days from the gross service as non-qualifying service, which is contrary to the mandate of the court rendered in judgment and order dated 24/3/2010 passed in writ appeal number 145 of 2009. So the authorities, according to the petitioner, the authorities have taken into account only 15 years, 28 days and 28 months and 28 days of service while calculating the pension, and as a consequence thereof, petitioner's husband was getting lesser pay. Stop. The husband of the petitioner, however, expired when? When did he expire?
25 to 2002.
25 to 2002. Therefore, as the spouse of the employee, the petitioner is entitled to the family pension to be calculated at the appropriate rate as have been directed by the court, by the judgment and order dated so and so, fast in writ appeal number so and so. Well, this court is of the view that when a judgment is rendered by this court and thereafter similar orders have been passed by the court, it is incumbent on the state to ensure that other similarly situated persons, if available within the department, are required to, their cases are required to be examined by the department to ensure that people are not forced to come to litigation, more particularly the legal heirs of the employees, for enhancement of the pension. Stop. The respondents on the next returnable date will place before the court the status as to whether any such steps have been undertaken by the respondent to find out the status of all such claims of pension or family pension, where all such claims of pension and family pension to have been issued at a lower rate by deducting certain years of services from the gross services rendered by the employees in contravention to the judgment and order dated 24/3/2010 passed in writ appeal number 145 of 2009. Stop. This information is necessary so that effective orders in these matters can be passed by the court. Let the matter be listed again. On 7th of January.
Lordship, if I may pay for that an observation that this repetition has been filed belatedly.
Why do you want an observation?
Lordship, because it has been filed belatedly. Lordship,
Have we stopped you from taking that objection?
no,
We are issuing a notice.
no, Lordship.
Yes.
Made the lawsuit. All of this matter relates to appointment of Gangura, my lord. So I
Appeal dismissed.
My lord.
Review.
Not review, my lord, yet to be filed, my lord.
Go and file a review.
My lord, a similar order also will find at page 88, my lord. Also.
Page
88, my lord.
88.
No, 62B, my lord.
Yes, Mr. Hendrik.
Lordship. This is regarding only for my lord that review file, my lord, that
Dispose it off.
One aspect I'll like to draw your lordship attention, my lord. That 162D, it said, my lord, provided that petition for review shall be accepted by the state government after the expiry of 90 days.
lordship already been.
We have directed them to file you within
No,
1
my
month.
lord, I have filed. I have to file the appeal within 90 days as per the my lord, provision. But they will take up the my lord, review after 90 days. So, my lord, that protection.
Where is the provision? Let us see.
My lord, I have gone through the books later on, my lord. As I was confused, I have also downloaded the gazette notification, my lord. Proviso to the 163D, my lord.
Details of the file visit.
Within a period of 90 days. When was this order passed?
I have to file the appeal, my lord, within the period of 90 days. It was 11/11. It is within the limitation, my lord. So, my lord, but proviso also will kindly see the proviso.
No. Perhaps what was sought to be conveyed was you file under 162B, then you file under 162C, and thereafter you come
162D.
under 162D.
My lord.
In the process.
The word is perhaps missing in the proviso, my lord. What I have understood, my lord. It should have been shall not be taken up after 90 days.
Yeah, perhaps.
But in the
That interpretation will make the entire proviso unworkable.
I don't know.
Anyway.
So, my lord, the interim.
Within 90 days, my lord, they have to file a review petition. After that, my lord, it will process. My lord, if it is filed, my lord, earlier, my lord, that it will full process accordingly.
No, we'll pass similar orders.
Lordship.
Till the my lord, review is taken up. Instead of 1 week, my lord. Till the review is taken up by the authority, review authority, my lord.
We have passed now.
Yes,
Why
my lord.
alter
In
it?
that case also, my lord, the review has not been taken up till today, my lord. I have
No,
only-
then we'll have to add something more. Disposal, heard, so and so, disposed in terms of this order, last order, page 89. The para 6 last dot provide you. Underline for a line, change for it. Shall not be relieved of his post of in charge Gangura till the review is disposed of. Stop. The review shall be disposed of within a period of 3 months from the date of receipt of from the date the review application is filed by the petitioner under instruction executive instruction 162-D. The interim order passed will, however, will continue till.
My interim order, my lord, he is not serving as a, my lord, that Gao Pradhan lord.
He's serving it.
No, my lord, this private respondent is the, my lord, is appointed as a Gao Pradhan lord.
Oh, then it is not applicable to you.
Lordship, he is not applicable to him.
Instruction to that, my lord.
Then why are you making this prayer?
Still,
My lord, as because lordship may kindly see.
Filed a writ petition, my lord, he was not appointed.
Then how is the interim order?
My
applicable?
interim order is not be applicable to the petitioner.
Try to mislead.
No, I am not trying to mislead, my lord.
What are you doing?
When I filed a writ petition, my lord, there is no appointment.
Then why are you asking for an
Thereafter-
interim order?
That is why, my lord, I have not been instructed, my lord, updated in this instruction I have not given.
No, you have not
But
been
when
instructed.
I
You
filed
go
a
by your
petition-
instructions as on date.
My lord, when the writ petition was filed, my lord, there is no
As on
appointment.
date, are you instructed whether he is being given charge?
No, my lord.
That's the end of it. If the appeal is filed within, then the petitioner, then the same shall be decided. Is there any time frame for deciding the review?
No, lordship.
We'll give 3 months.
Lordship.
Shall be decided within a period of 3 months from the date of receipt of the review by the by the review authorities, by the authority entertaining the review. A total part 2 now again. A part 2 now again. Yeah, disclose.
My lord, about the appointment, my lord, I was not informed, my lord.
That's all right, but I don't pray for it.
Objection, lordship.
Lordship, I appear for 4, 5, 6.
Mr. J. Hendik for
1, 2, and 3.
1, 2, and 3. Mr. D. Bora for 4, 5, and 6.
Item 3.
Please, your lordship. Your family pension regarding the unmarried dependent daughter. The petitioner's father was serving as a sub-inspector in the Assam Police. District Executive
Has it
Force.
been granted? No.
No, your lordship.
You have applied for.
Yes, I have made 2 representations. Annexure 1 in the year 2021, 8 October, Annexure E, page number 22.
Yes, respondent.
Lordship, I am for the accountant general, Lordship.
Yes. Would you like to get instructions?
Only representation, Lordship, there is some format, Lordship. She is claiming unmarried dependent daughter's pension.
Your lordship, I have also made another one.
These are not submitted to accountant general.
Yes, Lordship. And moreover, Lordship, he filed one RTA application also, that is also pending, Lordship. So section 19(1) of RTA applicable, Lordship.
Well, I have made the application because after my application was forwarded to the
Yes,
SP office.
government, who's appearing?
Lordship, I am
Can
appearing.
you obtain instructions
Lordship, I shall obtain instruction.
or we issue notice?
No, Lordship, I will obtain instruction.
I heard counsel for parties. Petitioner claims to be the daughter,
Yes,
unmarried daughter,
unmarried dependent daughter.
unmarried dependent daughter of one
Hiranmay Purkastha.
late Hiranmay Purkastha, who was serving under the Assam Police. So the claims of family pension made by the petitioner has not been granted by the respondents in spite of representations being filed. Being agreed, the petition has been filed, present petition has been filed. Correct. Mr. Sarkit Talundar appears for the accountant general. M. Bhattacharya, additional senior government advocate, appears for the respondents. 1, 2, 3, 4. She prays for some time to complete her instructions in the meantime. Although notices are not issued, extra copies be furnished within a period of 1 week. Within a period of 2 working days. You are appearing?
Yes, 2, lordship.
For responding to Mr. Nayak, please for responding. M. Bhattacharya for 1, 3, and 4. R.K. Talundar for responding number 5. Let the respondents complete their instructions. This is the matter again on 19th of
Yes, Lord.
January
Deeply obliged.
for motion.
Item 4.
Wait, please, my lord. My lord, ITC was imposed against us, my lord. We are a petitioner for my lord. My lord would kindly have page 32, my lord. Notice issued by the respondent number 4, my lord.
Yes.
May I read, my lord? Dear taxpayer, from information intelligence available at this end, it is seen that you have availed ineligible ITC amounting to rupees 1,07,561 without actual supply of goods from Messrs. Garg Coal Traders, which is non-existent. The details of the ineligible ITC are given below.
You have filed reply.
Yes, my lord, I have filed
And
reply.
the order has been passed.
Order has been passed, my lord. First, my lord, our registration was suspended, my lord. Against that, we had paid a certain amount of rupees 1,07,000. Then again, my lord, our registration was restored. But again, we received the impugned order we had received, my lord. There we were said that we have short paid this much amount. That again, our registration was suspended. We had made a payment against that in protest, my lord. Against that impugned order, I have come before this court today.
Where is that order?
My lord would kindly have paid 61, my lord. 10/21, 10/25. Page 61. May I read, my lord?
This is a show cause.
Show cause, but my lord, at the end of this, my lord, our registration stood suspended, my lord, under the provisions of the CGST Act and rules, my lord. May I read, my lord?
No. First, tell us, after the first show cause notice, you submitted reply.
Yes, my lord.
What order was passed?
My lord, nothing was interfered with. We were not given any reply, my lord.
Then who filed an appeal?
Appeal we didn't file, my lord. That is the other party, my lord, against whom we had entered into trade, my lord. The Messrs. Garg Coal. My lord, our anxiety in this case is that, my lord, although we had filed reply wherein we had appended all the returns, my lord, but that was not taken into consideration, and subsequently again the show cause, through this show cause notice, my lord, Annexure 11, page 61, again our registration stood cancelled. Pursuant thereto, my lord, we had made the remaining payment, my lord, but under protest. That is our challenge, my lord.
Yes, Mr. Setia.
Lordship, it's only a show cause notice, my lord, for not depositing, my lord, interest and penalty.
They have deposited now under protest.
Under protest, we have deposited. My lord would kindly have page 62, my lord.
They have deposited under protest.
Yes, my lord. Page 62, bottom portion.
My lord, they have to file their reply, my lord. It's only a show cause notice, and in fact, my lord, 7 days time were granted, my lord. It was issued on 21/10/25. And suspension, it is, my lord, temporarily, my lord. It is not, my lord, cancellation, my lord. And my lord, section 29 2, my lord, proviso, it's authorized my lord, the officer, my lord.
Why don't you file it?
My lord, reply also previously also, my lord, same cause of action, my lord. That is the
Whatever it may
interesting
be.
fact. My lord, same cause of action, same transaction, same ITC. We had already made payment, my lord. Again, subsequently to a
No, your making payment will not absolve the responsibility of making payment. Otherwise, if you are required to make at the relevant point in time.
My lord, to this, my lord, I have one humble submission, my lord. My lord, may kindly have section 29 of the CGST Act, subsection 2A, my lord, for a moment.
Section 20.
29, my lord, of the CGST Act, subsection 2A. May I read, my lord?
Yes.
The proper officer may cancel the registration of a person from such date, including any retrospective date, as he may deem fit where a registered person has contravened such provisions of the Act or the rules made thereunder or prescribed there. My lord, here, my lord, I would beg to state that, my lord, opportunity has to be given us, my lord, where we have contravened, where contravention is done. They'll
You
have
have
to be
been given,
satisfied.
you are not replying to it.
Reply I have filed, my lord. Reply, my lord, would kindly have at page 49, my lord, Annexure 7 and 8. Here we have already disclosed, my lord, same cause of action.
Mr. Setia, please get instructions.
Lordship. In fact, my lord, Annexure 9, page 56, for a moment, your lordship may see, my lord, that was the undertaking given by them, my lord. That's an affidavit, lordship. Page 56.
Yes.
Relevant portion, page 57, lordship. Para 1, I will pay the amount of rupees 1,07,000 so and so against the above mentioned demand order issued from DST issued so and so. The balance amount of interest and penalty will be paid within 1 month from the date of signing of this undertaking. That was not paid, my lord. And therefore, my lord, even in the my lord, impugned notice, page 61, your lordship may see. Remarks. The taxpayer has not paid the due interest and penalty in contravention of the CGST Act and rules after being submitted self-undertaking in due course. So therefore, this notice was issued.
My lord,
Now this amount has been paid.
That was not paid, my lord.
now it is paid, my lord.
It is paid.
I have to take the,
Ah,
my
you
lord,
take
instructions to be
instructions.
lordship, lordship,
Come back on Monday.
lordship.
Monday
Lordship, next one.
or Wednesday.
Should be any rate, lordship.
Third counsel for parties, the petitioner is agreed by the impugned show cause notice dated 21/10/2025, whereby the respondent authorities issued show cause to the petitioner, asking them to show cause as to why their registration should not be cancelled, which was otherwise suspended with effect from 21/10/2025. So pursuant thereto, the petitioners under protest has paid the total amount of,
My lord,
what is the amount you have paid?
my lord, the total amount now, being both the payments, 2,49,389 cumulative.
2,49,000.
The full delay.
This is 78,037 and 63.
My
Which
lord,
amount have you paid?
my lord, both, my lord. The first was, my lord, 1,07,561. And
Where is it reflected? Here in page number 62.
page 62, my lord, my lord, taking into account the previous payment, which is there at, my lord, page 46, my lord. Page 46, where we have paid. Sorry, my lord, page 60, my lord, 60. 60, the first payment. And then, my lord, page 62, the second payment. Since we have paid the amount, that is why the proceedings were dropped first. That 1,07,561 we had paid, my lord, first.
According to the petitioner, the amounts have been paid under protest. However, the proceedings have not yet been dropped. Therefore, the petition is before this court. Where Mr. S. Setia, learned standing counsel GST.
CGST lordship.
So he submits that petitioners had themselves undertaken pay the amount by virtue of an agreement, by virtue of an undertaking submitted by the petitioner, which is enclosed to the petitioner as Annexure 9. So they had undertaken to pay an amount of rupees 1,07,561 in response to the demand already made by the department. So it is submitted that as the petitioners had failed to pay the amount honoring the undertaking, the subsequent show cause notice was issued. So he, however, submits that he'd like to complete his instructions as to whether what the status of the proceedings pursuant to the demand being met by the petitioner under protest. Mr. Setias commits that we will be able to obtain his instructions by the next date within a few days, and therefore the matter be listed again on 10th of December. Although notices are not issued, extra copies be furnished within the course of the day to enable Mr. Setia to obtain the required instructions. List on 10th.
VP obliged.
I am obliged.
This is against dismissal from service, my lord. The appeal has also been dismissed now.
Third counsel for parties, petitioner has been dismissed from service by initiating proceedings, department proceedings under the Assam Service Discipline and Appeal Rules 1964. Stop the appeal filed by the The petitioner also has been dismissed. Present writ petition has been filed. Considering the submissions made, issue notice, returnable 4 weeks. Mr.
A. Fukan for respond number 1.
For
Respond number 1, ma'am.
respondent number 1. Mr. C.K.S. Borwa for respondent number 2. Since the respondent are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. Respondents may endeavor to file their counter affidavits in the meantime if so required.
Deeply appreciated.
Please, Your Lordship. My lord, the petitioner has participated in the recruitment process for the post of my lord diploma engineer PWD, my lord, and our limited grievance, my lord, the final list has been published, my lord, without showing the any reservation as per EWS.
Your roll number is not there.
My roll number is not in the final select list.
Yes, APSC.
My lord, his petition is not maintainable because my lord, your lordship kindly see, he's applied for the quota of EWS. He says, my lord, but there is no provision for EWS, my lord. The lordship kindly see, there is no EWS reservation, my lord. As per that is, my lord, that is as per your lordship kindly see the pair, my lord. The pair, my lord, page 15, my lord. Page 15, my lord.
Yes.
Your lordship may please to admit the petition, call for a record issue, ruling the calling the respondent focus as to why the appropriate lead or order any other direction shouldn't be issued, directing the APSC to amend and modify the impugned final select list dated 11/11/2020 by showing the candidate selected against the EWS category as per provision of OM 14/2019. So in advertisement and as per the advertisement as per the OM, that OM has already been, my lord, government of Assam, my lord, kept in abeyance in 2022. So nowadays, my lord, that's why it is in advertisement, there is no provision for reservation of the EWS, my lord. So since there is no provision for EWS, my lord, how he can claim in EWS, my lord? He can claim in the general, my lord.
Do you have that?
Yes, my lord, that notification is there, my lord. OM that is.
Yes, it is suspended.
There is no provision for EWS.
You are not aware.
Not.
Can you share a notification?
Yes, yes, my lord.
Give him a copy.
Yes, this is the copy. In that case, they have to, my lord, if they are not satisfied, they have to challenge the advertisement at that point of time, my lord. Because in advertisement, there is no mention about the reservation of EWS.
Counsel for the petitioner who has approached this court seeking a direction to the respondent APSC to disclose the candidate selected for the process of recruitment for junior engineer against EWS/BPL category in the select list published. Petitioner claims to be a member of the EWS/BPL category. Correct. Mr. T.J. Mohanto, learned senior counsel, assisted by Ms. P. Sharma, appearing for the APSC, has placed before the court the OM dated 21st of December 2022 to submit that by office memorandum 21st of December 2022, the earlier OM dated 2/2/2019 and 14/4/2019 notifying reservation for economically weaker sections in direct recruitment have been kept in abeyance until further orders. Stop. Mr. Monto therefore submits that in view of the subsequent notification dated 21st of December 2022, the APSC is not required to publish the select list against select list for candidates against
In fact, advertisement, there is no provision.
BPL category. And more particularly when this in the advertisement also no such reservation was mentioned. Counsel for the petitioner submits that he would like to complete his instructions in the matter. Raise for a week's time. Please take an afternoon. Mr. R. Bor appears for the PWD department.
Lordship, for the time being. For the time being, Lordship.
For the time being.
Yes, Lordship.
All right. Time being.
May it please the Lordship, my lord. My lord, this matter relates to non-payment of leave salary, my lord. As per the decision of the, my lord, board, my lord, the petitioner who is works as a senior section assistant is entitled for, my lord, leave salary, my lord, page 13.
Board means?
Board means, my lord, Assam Urban Water Supply and Sewerage Board, my lord. Page 13, this is their own decision, my lord, in pursuance to minus the 6/1/2010. On leave and medical will be entitled for the works as employee of the board.
No, Mr. Bora.
My lord, late notice go, my lord.
Urge Direct Counsel for parties. Petitioner is agreed that the earned leave and medical leave which work as employees working under the Assam Urban Water Supply and Sewerage Board are entitled to. Stop petitioner was, he was a former employee.
Yes, my lord.
Former employee of the same.
It was retired on 31/1/2024.
Superannuated on
31/1/2024.
31/1/2024. Stop. The grievance of the petitioner is that the
On leave, my lord.
earned leave. Leave salary for the
Earned leave.
utilized earned leave. Receivable by the petitioner has not been released in spite of the decision of the board as far back as 13/4/2010. Well, considering the submissions, issue notice returning in 4 weeks, Mr. S. Bora.
No, I have
appears on
1,
behalf
2,
of
3, and
all-
4.
All?
Not one, all 1, 2, 3, and 4.
1, 2,
3, and 4.
3, and 4.
5 is someone different, my lord. This is
This is urban water supply.
urban. It is urban. This is some different, my lord. Finance and accounts urban. It is not part of the Guwahati Metropolitan Drinking Water and Sewage.
No, Guwahati Metropolitan, earlier it was Assam Urban Water.
No. That's why, my lord, you have to take steps, my lord. Finance. It's a different, my lord. Assam Urban Water Supply.
No, you are working under which board, Mr. Das?
My lord, this, my lord, Assam Urban Water Supply and Sewerage Board, my lord.
Then why have you added this Metropolitan Water Board?
My lord,
Guwahati Metropolitan Drinking Water and Sewerage Board.
my lord, that 2015, my lord, that board has come into, my lord. This board has, my lord.
Taken over?
Yes, my lord, that's what.
Where is that statement?
Yeah, I have, my lord. Here in this petition, I have not made that statement.
You have not
Yes.
made that statement.
Yeah, but another writ petition, my lord, on the similar count, That is also pending. There I made this statement, my lord.
How are we connecting this?
WBC, my lord,
Sir.
this matter will be take along with WBC, my lord.
Thus, counsel for the petitioner submits that the board under which the petitioner was rendering service, namely Assam Urban Water Supply and Sewerage Board, has subsequently
Finance and accounts.
been taken over and of legal renomenclatured as Guwahati Metropolitan Drinking Water and Sewerage Board.
My lord.
So. What look like it, so you accept notice on respondent 5 also?
Yes, my lord. Earlier, other revision he accepted, my lord. WBC
let,
5084.
he takes steps on respond number 5, my lord. Otherwise it will be difficult on.
Why? Finance and accounts officer.
Yes,
Urban.
his own.
But urban water, it may not be urban water.
I can
It
I
may
can
be
state
Guwahati
fix-
Metropolitan.
Malo, here, malo, page 12, serial number 4, down below, kindly say, malo, copy 2. The Finance and Accounts Officer, Assam Urban Water Supply Sewers Board,
where-
Guwahati
where-
5. Page
This is
12,
urban.
Page
page 12, malo.
12.
Copy 2, serial number 4. This is the authority, malo. Finance and Accounts Officer.
This was issued in 2007.
Yes, yes.
So now today, what is the position? Is
This is-
he under Assam water supply or is he under Metropolitan?
Malo, original department is this, malo.
Is the department still available?
Board is, serial number,
Alright,
respondent number
what
3
the
is a executive
steps of
engineer.
respondent 5 within 1 week from today by registered post.
Yes.
Since Mr. Bora has entered appearance on behalf of respondent 1 to 2, offices away, the extra copies will be furnished within a period of 1 week from today.
Can it be, take along with the pending another
It is
petition?
submitted that similar filed by the same petition.
Say, this is another petition, same really.
Similar writ petition
5084
raising similar
2025.
issues is pending. It is submitted that both the writ petitions be listed together accordingly. Let the matter be listed along with WPC
5084 2025.
5084 2025.
Item 9.
Please, Lordship. Here the petitioner was working as Indo-Tibetan border. And he was on leave for 60 days thereafter, but he could not join. And thereafter, due to his difficulties, Your Lordship, and then he was continuously having contact with the department. But on 27 but a letter was received by
You're terminated.
Deserted.
You're terminated from service.
Deserted, Your Lordship.
Deserter.
Deserted.
He has not preferred appeal, nothing
There is
else.
an appellate provision.
And moreover, Lordship, he has not made ITBP a party to the
ITBF.
ITBP.
ITBP.
Yes, and he had made CRPF as a party respondent, Lordship.
You're working as what?
Constable ITBP, Lordship.
You are appointed as Constable ITBP?
Yes. And the order was passed by the he had made CRPF as a party.
Where is the impugned order?
Page
27.
23.
20.
Type copy is Lordship at
27 is exactly that exact. 27.
This is issued by ITBP.
Yes. And he had made CRPF as a party respondent.
I may allowed to amend certain.
What happened?
I may allow.
Paste.
Yes. Typical.
You withdraw and file a fresh one.
Lordship.
Counsel for the petitioner is permitted to withdraw the writ petition as certain corrections are required to be incorporated in the course title. Prayer made is allowed. Writ petition dismissed on withdrawal will be voted.
Lordship.
Yes, yes.
Lordship, in this case, petitioner working as Khalashi Lordship, but they are performing duties in the grade 3 post since the year 2013 and 14. Their name was recommended for.
Where is your appointment order?
Lordship.
Initial appointment order?
Lordship, it is, they were engaged initially as master or subsequently their service were regularized.
Where is that regular?
Lordship, Annexure 1, page 19.
Hmm.
Few I have annexed, but Lordship others have also.
Where is that list of names?
Lordship, serial number 7, page 19. Name of the petitioner number 1 is there.
Hmm.
Page number 20, Lordship, serial number 7.
Yes.
And Lordship, page number 21, serial number 7.
Then after that?
Lordship, you have annexed, but others, Lordship, I have not annexed. That I can furnish Lordship at the time of hearing, Lordship, if Lordship allow.
Now, what is your claim?
Lordship claim they were working in the, now they are working in the grade 3 post. Their name, Lordship, kindly have a look at page 26, Annexure 2. Their name were recommended for upgradation from grade 4 to grade 3. Page 26, Annexure 2. It is the forwarding letter and Lordship in the
20?
format
26.
Lordship, page 26. Sub upgradation of grade 4, Khalashi to grade 3 post. Lordship got it.
Where does it show that this is recommendation for upgradation?
Lordship, it is at the top, sub upgradation of grade 4, Khalashi to grade 3.
Okay.
Then your Lordship kindly have a look at the format. Page 27, start from page 27.
Now you are still, now then what happened?
Then Lordship, it was again recommended by the respondent number 3. Lordship kindly have a look at Annexure 3, page 54. To the Secretary to the Government of Assam on 24/1/2022.
Yes.
Page 54. Lordship got it. Their name is there, but till date, few of the
They're still working.
Lordship.
They're all working.
Lordship. Few of them retired from the list, but the petitioner before your Lordship still working.
The few of them retired means
From the list, not from the petitioners.
heard counsel for parties should notice returnable for weeks. Mr. R.R. Gogoi, he is on behalf of all.
No, respond number 1, 3, 4, 5, 6, 7, 8, 9, and 10. Except 2, your Lordship.
For all respondents except respondent 2. Ms. H. Bora for respondent 2. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. List again after returnable date.
Obliged, Lord.
Pendency of the writ petition shall not be a bar to consider the claims of the writ petition.
All right.
Yes.
Against the impugned order under the GST Act, which is and challenging as a time barred assessment, Lordship. Similar matter, this honorable court has already passed orders where the extension of limitation of passing estimate order section 73 has been set aside. But subsequently, the department has filed appeal which is pending in this honorable court, Lordship.
Where is that order?
Lordship, this is the copy of the order whereby the notification was set aside.
You have not enclosed?
I'm not enclosed because.
Yes, Mr. Setia.
Lordship, this particular notification 56 of 23 that was set aside and appeal is pending. And in fact, my lord, the same issue that is pending before Honorable Supreme Court. And subsequently, my lord, various writ petitions filed before this court, my lord, where my lord notices were issued, my lord. Here in this present case, my lord, they have already availed, my lord, alternative remedy. They filed an appeal against the order in original, my lord. And the appellate authority has dismissed the appeal, my lord. Against that, my lord, further appeal lie, my lord.
We are on the point of
Issue notice, you take up
Lordship.
heard. Counsel for petitioner issue notice returning 4 weeks. Mr. S. Setia appears on behalf of all.
2, 3, and 4, Lord.
2, 3, and 4.
Lord.
Who's for 1? Mr. B. Chakravarti for respondent number 1. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. The challenge made in the writ petition is to the time barred assessments undertaken by the writ petition, by the department. The coordinate bench, by judgment and order dated 19 September 2024 in so-and-so versus so-and-so, has set aside and interfered with the assessments made, against which intra-court appeal is presently pending. Counsel for the respondent also submits that similar matters are also pending before the apex court. When is the appeal likely to be decided?
Till only delay condonation is pending, Lordship. IA is only for
Delay condonation.
Lordship. There is no stay in that one.
Till the next returnable date, no coercive action against the writ petition with respect of the demand. That's all.
Second item 12 was same. Item 12 is also same, only the
Same.
period is different.
All right. Same order, 11, 12.
Much of it.
Public.
Item 13.
This is seeking no payment of 3 components of VRS manner and it's a covert matter. The Lordship's own judgment of page 135.
Yes, respondent.
Irrigation department. Irrigation department. Irrigation department.
Irrigation, who's for irrigation?
The end of
End of items. Narayan
Yes, Mr. Upadhyay.
It's a short notice of.
Notice, he says it is a similar order can be disposed of.
Examine loss. It's a short notice, there are 2 weeks loss.
Keep it at motion stage. Let my learned friend verify.
You examine it, we'll take it up we'll take it up next Wednesday.
Loss.
Or on Friday. Wednesday.
Any day, Lord.
Right. Third counsel for parties. The counsel for the petitioner submits that this matter can be disposed of in terms of the judgment and order. In terms of the order dated 19/12/2023 passed in WPC 5681 of 2022 and other connected with petitions. Counsel for the respondent, Mr. N. Upadhyay, submits that he be permitted to examine the judgment. As agreed to, list this matter again on 10th December. Extra copies be furnished during the course of the day. Mr. P.K.S. Borua and H. Borua for the other respondents. Yes.
Lordship, my lord, the petitioners are, my lord, employee of, my lord, the Community Center for Plantation Labors. It is under, my lord,
supervision, control and supervision of, my lord,
What is your claim?
my lord, claim, my lord, my salary as recommended under, my lord, the 7th pay commission has not been paid, my lord, till, my lord, January 2019.
Yes, heard counsel for parties issue notice written about 4 issues for the labor department.
Labor Department, I shall appear, Lordship, but this pertains to. Yes, Lordship.
MS
Employees
M.
Covenant.
Bhattacharya appears for respondent number 1 and 2. MS H. Borua for respondent 5. Therefore, notices are waived. Extra copies be furnished within a period of 1 week from today. Steps on respondent 3 and 4 by registered post within 1 week from today. Respondents may complete their instructions and file necessary affidavit. Placed accordingly.
Obliged.
15.
Pleasure.
May I please the lord. My lord, petitioner before your lordship, my lord, they are the staff nurse, my lord, serving under the establishment of GMCH Guwahati, my lord. My lord, presently they are drawing, my lord, great pay at rupees, my lord, 6,800. And my lord, as per ROP rules, my lord, and as per judgment passed by this honorable court, I have annexed, my lord. They are, my lord, entitled great pay at rupees, my lord, 8,700. As my lord, they have now obtained, my lord, degree, graduation in, my lord, nursing, my lord.
Yes, madam, is it
Cover case, my lord.
It's covered.
I have to obtain instructions.
Please
also.
do. Heard counsel for parties. Claim of the petitioners is for grant of great pay of rupees 8,700
8,700.
as they have in the meanwhile attained their degree.
Degree post basic.
What is
BSc
the
nursing.
degree called? What is the degree called?
My lord, post basic nursing in post basic nursing degree, my lord.
You don't know that. It's completed the degree applicable. BSc.
BHC, my lord. Equivalent to postgraduate BHC nursing. My lord, I have annexed the document, my lord.
Where is the document?
My lord, your lordship kindly see page 47, my lord. 47, my lord. Second paragraph, my lord. This has been issued, my lord, Director of Medical Education, Assam. In this connection, your lordship, middle paragraph, my lord. In this connection, I am to enclose here with a copy of the letter issued from Srimanta Shankardeva University of Health Service, Guwahati, regarding the equivalent of the post-basic BSc nursing course with the BHC nursing course. Equivalent, my lord, they are.
The petitioners in the meantime have completed the post-basic BSc nursing degree, which according to the petitioner is equivalent to BSc nursing.
BHC nursing degree, my lord.
Degree. Stop. And therefore, they are entitled to the claim of great pay. Stop.
My lord, I have annexed my ROP rule also.
This issue has already been settled by a judgment of a coordinate bench, which is also enclosed to the petition. MSD Bora, Standing Counsel for the Health Department, submits that she would like to complete her instructions in the matter. MS H. Borua appears for the respondent number 3. Since although notices are not issued, extra copies be furnished within a period of within 2 working days. Let the matter be listed again on 12th
Obliged, my lord.
of December.
May I please the lordship?
Yes.
Similar situated person was got higher voluntary retirement benefit than to the petitioner, lordship. It is the grievance, lordship. Petitioner got lordship 9,26,878 and other petitioner 12,06,571 rupees, lordship.
Petitioner heard. Petitioner was employed in the AIDC
Yes, Lordship.
pursuant to the offer of VRS scheme notified by the AIDC authorities, the petitioner applied for and was offered and was given the AIDC, a VRS. Stop, however, it is the grievance of the petitioner that unlike the other similarly situated employees, the amount received by the petitioner is less than
Yes,
the
sir.
amount which was granted to the other person. Stop. According to the petitioner, she was granted an amount of rupees
9,26,878 rupees.
9,26,878 rupees as compared to rupees
Rupees 12,06,571 rupees.
12,06,571 rupees as granted by issued to some other similarly situated persons. So, did you file any representation?
Yes, Lordship.
Where is that?
Annexure F, Lordship, page 24, Lordship. Barnacular, page 25, Lordship.
She filed representation as far back as 28/9/2022 to the respondent authorities. What reply was issued?
That is at my lord, page number 28.
To which a reply was issued that the difference has occurred due to differences in basic pay for the periods in concern, periods under consideration. The department held that there was no anomaly in the calculation and the same was verified, cross-verified by chartered accountants, and also the amount was dispersed upon due approval by the government of Assam. So, petitioner being agreed, has filed the writ petition. Yes, what is to be done?
Let notice be issued, my lord, we'll file affidavit, my lord.
Issue notice returnable 4 weeks. Mr. S. Das for
234,
234.
my lord.
Mr. R for 1.
One.
Since respondents represented by counsel, notices of it, that the copies be furnished within a period of 1 week from today.
File,
File,
my
my
lord.
lord. File, file.
Wait, please. But pursuant to the judgments rendered by this honorable court in the case of Upen Das, my lord, a committee was formed.
Yes.
Lordship, civil. Open das, casual open, lordship.
Upen Das.
Similar.
That similar order, my lord, will find at page
You are
170.
agreeable to this order.
Lordship, already been passed.
You have verified.
They can
We'll
examine.
verify, we'll examine it. Lordship.
All right, heard counsel for parties disposed. Page number 201.
204 is the relevant portion, my lord.
204. Yeah.
Our names appear in the list dated 9/5/2025. Page 204. Examine going to the file that we will- They can examine, and if they find,
There is no mention about list.
no, that list, my lord, will find in page number 122. Page 122, my lord. This is the list of submission of the list of the left out candidates. The list
Petitioners were
left
left
out.
out candidates and their names are mentioned in the list furnished by the additional principal chief conservator of forest. CHP Boroland Territorial Council, Kokrajhar, by the communication dated 9/5/2025. So the list enclosed includes the names of all the writ petitioners.
All the reports.
Already. Dispose.
Obliged. Deeply obliged.
Mr.
BC Musahari,
BC Musari, it is for Boroland,
ETC, respondent number
as
5
well
and
as the
6.
forest.
5 and 6, lordship, respondent number 5 and 6.
And who is for the other?
Others,
We have served copy, the name is shown in the cause list, but none appears.
All right, Mr. B.C. Muzari appears for respondent 5 and 6.
5 and 6.
Obliged.
Declare. Is agreed.
Supplementary motion item 33. Now, this is regarding my selection and appointment of Anganwadi helper, my lord. Not kindly see, my lord, the comparative statement, page 30, petitioner got the highest mark. But on the basis of a certificate of disability, the respondent number 8 has been appointed.
How do you know it is a fake?
Kindly see the certificate, my lord, page 28, my lord.
28.
Yes. There are different handwriting, my lord, different ink also.
That is. How do you make out different handwriting?
And kindly see, my lord, number 183, my lord.
Huh?
In the certificate, 183, my lord. Then
180.
date, my lord, kindly see. The different, my lord, handwriting, and then name and address, my lord, filled up, my lord. In the middle also, my lord, 183/204, that is also different handwriting, my lord. And my lord, kindly see
You
the.
verify and see that.
Kindly see the seal, my lord, seal in the photo, my lord, kindly see. Photo also, my lord, one photo was removed and another photo was pasted, my lord. The mark is also there in the seal also.
You have got the original.
No, original I cannot go.
You got only the photocopy.
The photo also shows there, my lord, kindly see, my lord.
Yeah, you should be working in the forensic department.
The primary official matter, it shows there, my lord. Take instruction, my lord. Health department is made party, my lord.
How will it take instructions on? Right. Heard counsel for parties. The petitioner is agreed that the private respondent number
8, lordship.
8 is agreed by the appointment of the private respondent number 8 as what?
Anganwadi helper.
Anganwadi helper.
At Poschim Tarangapur Tiniali Anganwadi Center.
In Poschim Tarangapur Tiniali Anganwadi Center. To which post the petitioner had also applied. Stop. It is the claim of the petitioner that the private respondent submitted a fabricated certificate showing her to be a person with disability, and thereby she had secured the appointment. Stop. The counsel for the petitioner, referring to the photocopy of the said certificate enclosed to the writ petition, has attempted to draw the attention of the court to the various to the entries in the said certificate, which according to the petitioner bear different handwritings. Stop. It is also the claim of the petitioner that from a bare perusal of the form, it appears that the photograph of the private respondent has been affixed by removing some other photograph. Stop. At this stage, the court is not inclined to issue notice. However, the court permits the learned senior government advocate appearing for all the respondents.
No, lordship, 1 to 6 I am appearing.
1 to 6.
7 is health department, lordship.
1 to 6 is permitted to complete her instructions by obtaining the relevant information with regard to the genuineness of the certificate issued by the private respondent number 8. Stop. Mr. D. Upamanu appears for respondent number 8.
We have not
Seven.
furnished
Seven.
a copy, lordship.
7.
Our name has also not been shown.
I will start my.
Let this matter be listed again on 7 January. 7 January.
My lord. My lord, instructions should also come from my lord, respondent number 7 also, my lord. They are
We are asking them to obtain instructions. You serve copies
My lord, I will-
within 2 working days. Extra copies.
Obliged, my lord.
It's 6-3.
Daily super orders are making.
Replay, my lord.
Lordship, here in this matter, the petitioner, perhaps Lordship, don't want to continue with this contempt. Lordship, they have filed an affidavit before the Joint Director of Health Services, Kashar, stating that he may be given the
Where is that
benefits.
affidavit?
Lordship, it is as an instruction, Lord.
No, but has the order been complied with?
Lordship, the direction was to furnish a representation before the Director, Lordship, which he did not do, Lordship. But then, Lordship, once we came to know about this petition, Lordship, we gave instructions to the concerned authority, Lordship. But the authority has received this affidavit, and Lordship, now his GPF and leave encashment has already been released. And this is a instruction of June, Lordship. So
The contempt petition is filed by the petitioner alleging willful disobedience of the directions contained in the order dated 2012-2021, passed in WPC number 2307 of 2017. By the said order, the following directions were issued, page 14 and 15. Stop. However, but he has filed a representation.
Lordship, once we came to know about it, Lordship, the representation which is annexed, Lordship, we have not received it, Lordship. We have stated in one of our instruction, and it has been reflected in one of the orders also, Lord.
The petitioner claimed to have filed the representation in pursuance to the directions of the court. However,
At page 16, Lordship.
department disputed the claim that the representation was received by the department. So this is also reflected in the earlier order passed on 14/8/2023. So since this directions was not complied with, the contempt petition was filed. In the meantime, you have released a what?
GPF and leave encashment, Lordship.
I did.
No, এটা আমাকে affidavit file করছে, এখন আমাদের Germany কাজ করা। So আমি ওনাকে leave encashment.
Yes, no, Lordship, in this particular contempt matter, there was a direction of this honorable court for the reinstatement of the service of the petitioner, and that has not been done. Several representations were also filed. So the release of other things I can understand, but so far as the specific direction, if your Lordship kindly see the contempt order.
Yes, file an affidavit.
Where?
Before the joint.
No, under compulsion, Lordship. This affidavit was filed under compulsion because he is without money. He is striving without money, and that is the reason why, Lordship, he has filed this affidavit, Lordship. He was not getting salary. He was not getting pension. Nothing else, Lordship. This order was passed on 2021. For last 4 years, and nothing has happened, Lordship.
Have you disposed of this representation?
Lordship, we have not received any representation, Lordship.
And very recently, Lordship, I have served another notice to the concerned person, Lordship.
On there is an order on 2/12.
Yes.
Exactly a year ago.
Exactly.
Thereafter, Lordship, we have made.
No, this order says is recorded the submitted a copy of the representation.
Yes, Lord.
Where there is an endorsement by the department they have received.
Yes.
So you were given time to obtain instructions.
But
No, that was copy was also given to him. Copy was also given to him, Lordship, because he asked for the copy and I served the copy to him.
Lordship,
And very recently, Lordship, this
no order was passed.
Lordship, that instruction I do not have. I have only received these instructions in the month.
Then we'll have to call your officer. Who is
Lordship, anyways, Lordship, I will get
Who
the
is the
instruction.
officer here?
Lordship, the current incumbent has not been made a party, Lordship.
No, I have I've served a notice to him also.
He is
Lordship.
assumed office.
Yes.
This Kamalji
He
Talukdar
is
is
required to be aware
No.
that there are orders passed by the court and he is required to comply with it.
He is the director of health services.
Exactly.
He is not the director of health services.
Okay.
Who is the director?
Lordship, Dr. Umesh. Lordship, I'll give the details, Lordship.
Lordship, this order was passed in
Who
the
has
year
given you the-
2021.
Lordship, this has been furnished by the director and the instruction received from the Joint Director Kachar, Lordship.
Order was passed in the year
And
2021.
Lordship, he has
The
given,
direction was issued to whom? The director?
yes, Lordship.
Now then,
And Lordship, he has given a notice to the Director of Health Services, FW, Dr. Kamaljit.
No, it has been recently given. I'll
Lordship.
serve another, but the prior
So,
to that,
Lordship, he is not the Director of Health Services.
prior to that, the notices were served, Lordship. And on the basis of that,
where is that copy of the endorsement?
endorsement I'm having, Lordship.
Because
On the last occasion, it was handed over to my learned friend also, Lordship. This is the endorsement. That was on 21. We can see the original copy.
let us see, let us see.
This is the original copy is also there, Lordship. 21 there.
Two different
Where is the original copy?
This is the original one.
Which one?
This one.
And Lordship, in this, there is no seal, Lordship.
Photos.
This was served.
This was served.
But Lordship, in the photocopy, Lordship, there is no seal, Lordship.
So forget about the photocopy.
No, no,
Give me
this
the
one,
original
this one, this
This is the original one.
Lordship, it will have to be Xerox from the original one. From where he got this, Lordship, the other one. The other one without seal, Lordship. The
Let me
Xerox.
find out.
Yes,
First you tell us whether this is there or not. You call your director.
No, Lordship, at least, Lordship, I'll maybe given time till
We
Friday.
have given you more than 1 year time. Your director is sitting over doing what?
Lordship, let him,
We should send them to the jail. Let them operate from the jail.
Lordship, let me get the instruction on Friday.
What were you doing for 1 year?
Lordship,
You've
he's-
been given time for 1 year.
Lordship, but the present incumbent has not been made a part.
Present incumbent not been made, we'll call the other incumbent out of retirement.
Lordship, I'll get the instruction by Friday, Lordship.
Court orders are not passed just for fun. When an order is passed, what are you doing sitting over the order?
Lordship,
And disputing whether this was served, that was not served. Even if it was not served, it was brought to your notice as a counsel.
yes, Lordship, and I have.
Was it not required on your part to go and inform your clients?
Yes, Lordship, we had informed, Lordship.
Let us
But
see
in
your
the-
communications. What have they done?
If there are communications, Lordship. But Lordship, this was way back in the year 2023, Lordship.
Therefore, we should call him.
23 communication is there.
Therefore, we should call him. For 2 years, what was he doing?
Lordship, I'll get the instruction on Friday, Lordship.
Tomorrow. Get it by tomorrow.
Yes, sir.
List this matter tomorrow.
All right, Lordship.
Enabling Mr. D. Upamanyu, Standing Council Health,
Yes, Lord.
appearing for respondents.
Lordship, currently, Lordship, I'm appearing for the respondent number 2, Lordship.
Respondent 2 as to why the directions contained in the order dated so-and-so, passed in WPC so-and-so, has not been complied with in spite of repeated opportunities being granted. If the instructions sought for are not placed before the court, consequential orders are likely to be passed.
Lordship, at 2 p.m. tomorrow.
Tomorrow at 2 p.m.
Public.
Copy of this order be marked to Mr. Upamanyu as well as to the senior governor, office of the senior governor. Copy ula it is so equal. So ill. Yes, Mr.
Okay,
SP. Probably please for the petition. Yes. You take back your original documents, whatever was there.
Can be kept on record.
No, we don't want to keep it. You take it back. Yes.
Order has been complied, my lord.
Show us. What was the direction?
My lord, directed to release the retirement benefits, my lord.
You bring an affidavit on record
My,
that it has been released.
my lord. Anyways, they have already received, my lord.
We don't know. You bring it on record. If you have sent it, you have documents, you show it to us.
My,
Next Wednesday, you bring it on record.
item number 20 and 21 also similar.
Counsel for the non-appeals for the petitioner on call, counsel for the respondent number,
So respondent,
sole respondent, Mr.
AD. AD.
A. Day.
Yes.
Submits that the directions contained in the order has since been complied with. He has placed before the court statement of the leave encashment and gratuity stated to have been released to all the employees whose names are there, including that of the writ petition. So we direct the respondent to file an affidavit to that effect and bring it on record by the next date fixed, list on 10th of December.
Item number 20 and 21 also.
20 and 21 similar.
Mashallah.
Then you'll have to file 3 affidavits.
Right. So
Do it.
actually, my lord, but difficulty is, my lord, it has been closed,
What is closed?
that particular department has been
Whatever the respondent is there, you have managed to get some document from there.
Well, that is the difficulty. Anyways, they have already received the.
You get some instruction as to
Mine.
whether they have received or not received. Show us that it has been credited in their account.
Yes, yes. Much.
May I please, Your Lordship? Your Lordship, we are the newly engaged counsel. We will file our reply, Lordship. Kindly 1 week time may be granted.
Counsel for the petitioner submits that they have been recently engaged in the matter. They require further time to file their rejoinder affidavit to the affidavit filed in respondents 4, 5, and 8. Remedy is allowed, list this matter again after 4 weeks.
Yes.
Mr. BC starting for BTC.
BTC, Lordship.
Mr. D. Bora for
1 and 2.
1 and 2.
24.
May I please, Lordship? My lord, this case relates to the non-payment of numeration as per the notification for some months, my lord. 5,000 per month, petitioner before your lordship was a president, man, of Gao Panchayat. And they are entitled for 5,000 per month for few months, my lord, they have been given 8 months. After that, it has not been given, man.
Have you taken steps on respondent number 6? Newly implemented. There is an office note saying that
I have taken.
No steps have been taken. Respondent 6 is the secretary. Government of Assam Finance. Who's there for finance?
6
is Government of Assam Finance. Office note dated 18/8/2025 reflects that petitioner was required to take steps on newly implemented respondent number 6 through the standing council, but no acceptance notice has been received by this section. Stop. Counsel for Finance is available in court, MS H. Borua, who accepts notice on behalf of the newly implemented respondent number 6. Any acceptance notices or appearance memos required to be filed by the standing council shall be done accordingly before the registry within a period of 1 week from today. Matter be listed for admission.
Admission, man.
Admission in January.
Not. Now phone number 2.
In the month of January. Then it will be there. Yes.
Phone number 2.
Earlier, they have to take in instruction, my lord. In earlier occasion, they have to collect the instruction.
Lordship, only 2 weeks time may be given, Lordship.
My lord, several dates have taken.
Appearing on whose behalf?
On behalf of the water resource, RM
Yeah.
Das,
How many, which respondents?
1 and 2.
Council for Water Resources, appearing for Water Resources, renew their prayer for further time. Purely for the end of justice, 2 weeks further time is granted to the Standing Council Water Resources to complete their instructions. Since the office note, since as per the earlier order, referring to the Lozima Court's order dated 29/7/2025, it was held that service on respondents number 5, 6, 7, 8, 9, 10 have been completed. And since none has represented the said respondents, matter will now proceed ex parte against the said respondents. Matter be listed in the month of January for admission.
My lord, can we please extend it, my lord?
Oblige, Your
And the
It is
petitioner
coming
will,
January.
petitioner will retire in the meantime.
19 January.
Oblige, my lord.
May I please your lordship? Service already completed, respondent not appears. Matter may be taken as an admission, lordship. Service completed.
As per office note dated 1/12/25, service on the respondents 7 and 8 has been no. Office will make necessary endorsements. The office note dated 1/12/2025 does not clarify whether service on respondent number 7 and 8 have been completed. Stop office to make necessary notes, necessary endorsements in the notes, office note, and the matter be listed again next week. It is not clear from the office note whether service is complete or not.
Can you fix a date, please?
And next week it is coming.
27.
That is, as per the office note, they said 27/5/2025, there's a deficit of the postal stamp. So lordship may allow 2 days, the deficit of the postal stamp.
Deficit.
Yes, lordship.
Counsel for the petitioner is permitted to take steps to furnish,
Deposit
the deficit court fee as reflected in the office note dated 27/5/2025. 27/5. What were you doing?
So now it's come to our knowledge. We have already
Matter be listed after 2 weeks.
Obliged.
Thereafter, MSP Sharma for APSC.
APSC, lordship.
MSH Bora for finance, D Bora for foreign.
Obliged.
Lordship.
28.
No, as per notice, as per official ballot, I may be allowed to take phase step to, so not 1 and 2. No answer.
Counsel for the petitioner is permitted to take fresh steps on respondent 1 and 2.
1 and 2.
As the office note dated 28/11/25 reflects that no ID card or unserved notice has been received back. Matter being listed after 4 weeks.
Diplo.
Item 20.
Readings complete.
Yes.
If the matter be listed for admission in the month of January. What is the issue here?
Lordship, there's a simple issue, Lordship, the license of the PDS license, Lordship, it should be converted in EPDS, Lordship. That is the issue.
It should be converted to
EPDS,
EPDS.
online system.
E-post, matlab, that device is matlab, required now to matlab, run the fair price shop. Matlab.
So why have you not provided?
Matlab, it is not the district authority, matlab, it will be by the commissioner and secretary matlab, department. So matlab, the contemner before your lordship has complied with the matlab, direction, matlab, sending the proposal to the matlab, state authorities. Matlab. Now there to matlab, issue that
Who is
e-post
the
device.
state authority?
Matlab,
Commissioner,
Commissioner, matlab.
Food and Civil Supply.
Yes, matlab.
Who represents?
They probably, matlab, the
Represents?
state government,
You represent, you are for one.
matlab, for district. of-
Yes, yes, Lordship, in the contempt case, he is
Commission-
not party, Lordship.
Commissioner was not party, matlab.
But Lordship, in page 11 of my contempt petition, Lordship, kindly see, Lordship, the order. Lordship, they agreed in paragraph number 9, the respond number 4 and 5, as agreed by the council for the state respondents representing them to complete the process of converting or entering the FPS license details of the petitioner into the EPDS.
Who is 4 and 5?
Lordship, this is the deputy commissioner and assistant director of food and civil supplies, district commissioner and that.
Yes, Mr. Bora. Please obtain instructions
Them none, that one.
from the deputy commissioner.
Yes,
South Salma.
actually, matlab, this case was,
You represent both.
matlab, requested by the court. I appeared in this case, so I can even take instruction from commissioner, matlab.
So
Lord
please,
Lordship,
please
may-
take and inform us.
My lord, lordship may be pleased to observe because commissioner was not party here. So lordship may be pleased to observe that the
Commissioner means commissioner of?
food and civil supplies department, my annexure 5, my lord, page 26.
We'll permit you to obtain instructions from, all right, heard, Learned Council for Parties, MSS.
You does,
You
my lord.
does, council representing the respondents 1 and 2.
My lord.
Submit that in terms of the directions contained in the order dated 4/11/24 passed in WPC 4/8/2022. The respondents have initiated the process for issuance of a license.
E-post machine, my lord, to complete
E what?
small e POS, my lord. Lordship will find it page 26, annexure 5,
E-post.
my lord.
E-POS.
POS capital, my lord, machine.
E-POS machine.
Lordship, basically, Lordship, for simple words, his license for should be inserted in RCMS, Online Ration Card Management System.
For that reason,
Yes.
machine is required.
Yes.
The matter has been forwarded to the Commissioner of the Food and Civil Supplies Department, Government of Assam, Stoke. Since the Commissioner is not added as a party in the contempt petitions, we permit MS Das to obtain instructions from the Commissioner of Food and Civil Supply. What do you call it? Food, Public Distribution and Consumer Affairs and Legal Metrology.
My lord.
81, Food and Civil Supply, page number 25 of the cash. To obtain all instructions as to the steps taken for issuance of the E-POS
My lord.
or EPDS/RCMS.
Yes,
Yes.
yes, that is the exact.
E-POS normal. It is page 25 what I say. EPDS and RCMS.
Yes.
Issuance of the EPDS/RCMS. Or you say sanction of EPDS with RCMS, enabling the petitioner to operate his
Fair brush shop.
fair press shop.
In E mode, online system.
on the e-mode. This instructions we place before the court on
January, fix a date.
when?
My lord, after 4 years, my lord.
Lordship, no, Lordship, January date, Lordship,
No.
7 January.
yes. Obviously.
7 January.
Obliged.
Reporting.
This is a contempt application, my lord. The respondent has filed an affidavit today itself by saying that they could not pay the subsistence allowance to the petitioner because of not given the budget allocation. And they have also not been stated regarding the subsistence allowance from 2018 to till date.
Let the affidavit be called for.
Yes, my lord.
Mr. R. Islam for the petitioner, MS so for respondent number 2. Mr. Islam submits that the respondents have filed an affidavit today. Stop. The said affidavit, however, is not connected to the case report registry to trace out the affidavit stated to have been filed by respondent 2 and connected to the case record. This will matter next week.
A date may be fixed.
Next week, some date it will come.
Obliged.
Master plan.
33.
Made to the Lordship. Some instructions my learned friend was supposed to bring to them.
Lordship, there is a cabinet decision, Lordship, at page number 8, Lordship. And next, the second paragraph, the cabinet also noted that so far 136 employees have not opted for VS. It was further directed that the agriculture department to decide on the continuation of these 136 employees. If the agriculture department can arrange for making payment of salaries of these employees from their available resources, the department may utilize their service appropriately. Otherwise, the department shall consider closure of ASMB.
So you fall under these 136.
No, my lord, there is
Yes,
a
Lord.
catch.
Yes, Lord.
If my learned friend is finished, my lord. This issue pertaining to whether I should be given VRS or compulsory retirement is already was under challenge, which is pending, and this court intervened and have given an order that you cannot compel us to take VRS. So that order is here, my lord. What my learned friend is trying to project is that, my lord, we are not opting VRS, so we are continuing to work under the ASMB, my lord, and they are saying that now because we are continuing, this fund, whatever was released, was not meant for us. Now, for VRS people, they have already taken VRS. The fund has been utilized, and I have not gone through the instruction, but what I've been told that they have already been paid their dues. Now he's trying to mix the matter which is pending. If your lordship may kindly see, there's an order of this court putting a status quo order on the services of this petitioner that you cannot compel us to retire or take VRS. That is already a challenge, my lord. My lord, may kindly.
No, what is the meaning of these instructions?
Yes, my dear.
Lordship, kindly have the page 3, Lordship. There is a clarification regarding the guarantee aid and fund utilization, page 3. Page 3, Lordship. Page 3. Page 3. Page 3, Lordship.
Employees, my lord.
Page 3, Lordship. Clarification on guarantee aid and funds utilization, Annex 4. As noted by the Honorable Court so-and-so, or that it is so-and-so, the petitioners contended that 30.5 crore was provided as guaranteed aid for salaries and retirement benefit. However, the actual fact is, Lordship, out of 20 crore release, 10.24 crore was utilized for payment of retail dues of the retired employee. Balance 9.75 crore remains in the ASMB account. Lordship, they have challenged that an amount of
What is the status of this writ petition?
Yes, my lord. In this writ petition, they were supposed to file the affidavit. They haven't yet filed any affidavit therein.
Affidavit that I will file within 10 days.
And the stay order has been continued in this subsequent order, my lord, until further order by this honorable court. So, my lord, they are trying to now bring a case in which we were compelled to take VRS and we refused to take VRS. And now he's saying that the fund which was released was not meant for us and trying to dilute the issue, my lord. Here we have nothing to do with the VRS case, my lord.
No, all right, you don't want to be VRS, you want to be there.
Yes,
it is
my lord.
Okay.
Yes, my lord.
But it is up to the authority to
Of
arrange
course.
for funds. If they think that this amount is to be released to
Yes,
for VRS,
my lord.
why should we stop
No, my
them?
lord. Here, the fund which is in question, if I may take my lordship to my lord, the demand proposal for which the fund was sanctioned was for us for payment of our outstanding dues, my
Where
lord.
is- Where is that? Where is that?
Yes, my lord.
Also, we clearly stated that the amount of rupees 10 crore 50 was proposed to be represent salary because peer settlement funds were insufficient to clear
My
their
lord,
dues.
kindly come to my IA at page number 35, my lord.
Aye.
IA.
So they have to challenge the cabinet decision.
Why should we sell, my lord?
But because in the cabinet decision, there is specific lordship.
IA, my lord.
Page number?
Page number 35 is the budget proposal for the year 2025-26, my lord, wherein our outstanding salaries were demarcated and it was proposed, my lord. May I read, my lord? It is from the Assam State Agriculture Marketing Board, 7th of January 2025. Subject is submission of budget proposal, my lord. Here, if your lordship sees, my lord, in inviting a reference to the above, I have the honor to submit herewith a budget proposal for an amount of rupees 96 crores and such odd figure for placing before the upcoming Legislative Assembly session of Government of Assam for inclusion of the amount in the budget for the year financial year 2025-26 under the following heads of account, State Marketing Board, in order to make, my lord, payment of salary, remuneration of the existing 136 employee, my lord. We are these existing 136 employees, and gratuity, leave encashment, and for retired and deceased employees and voluntary retirement benefits to the regular employees who opted for VRS. The following components are included in the said budget proposal. Now, component number 1, estimated salary, my lord, so and so. 2, component number 6, my lord, is where we fall. For 1 to 6, we fall under specific category of, my lord, clause number 4. We fall under clause number 4, outstanding salary. And, my lord, clause number 7, that is VRS, outstanding benefits for regular employees. Now, if your lordship sees the head of the account, my lord, the 2 components have been divided. The first component, head of the account, is around rupees 43 crores for serial number 1 to 6. So clearly, my lord, there has been a separate head of accounts created to make payments for the current petitioners and for the VRS opted, my lord, the employees. Now, my lord, may kindly come to the next page at page 36. The Droyal proposal was submitted by the board, wherein in the Droyal proposal, it is clearly indicated again, my lord, submission of Droyal proposal for 25-26. In inviting a reference to the above, I have the honor to submit herewith a Droyal proposal for an amount of how much, my lord? 30 crores, which is allocated under head of account such and such of grant number 48 in budget number so and so to meet the revenue expenditure of the board in following form. Number 1, outstanding and regular monthly salary. Here we fall, my lord. So they themselves have sent this 30 crores claiming that they need to pay our salary, my lord. Then kindly lordship may come to this sanction, financial sanction granted by the authorities for this amount at page 37, my lord. So here at page 37, my lord, the financial sanction has been accorded. If my lord sees the subject, it is purpose and the scheme. It says financial sanction for an amount of rupees 30 crores against what, my lord? Outstanding and regular monthly salary, my lord. And employees provident fund and leave encashment of ASMB under establishment expenditure of the year 2025-26. And the amount here, my lord, has been released is 30 crores. Now, according to this, my lord, at clause number 6, my lord, if I may just quickly take, it is indicated that there should not be any change in the scheme. Diversion of fund from one scheme to another will not be entertained under any circumstances. So what they're trying to do now, they want to divert this fund meant for us. Then your lordship may kindly come to this page 38, my lord, which is the fixation of ceiling. Even the ceiling was fixed and thereafter money was released to the account of the ASMB. And in the ceiling, your lordship will see here under the column, my lord, purpose and scheme, again, payment of outstanding and regular monthly salary, how much was released on the extreme right hand, my lord will see amount in X, 20 crores was released, my lord, directly to the account of the ASMB. Now it is from this.
There is a cabinet decision to wind up.
That was before, my lord.
So that has
this
it
money,
recalled.
this money that has been released to
Not
us, my
before,
lord.
not before.
Yes, my
Money
lord.
sanctioned was on 8/7/25.
Yes, my lord.
And the cabinet decision is on 19 or 10/7/24.
Before, cabinet decision is before them submitting. So the money which came today in the form of budget proposal was clearly meant for the payment of these outstanding salaries of these existing employees who refused to go for VRS, and in which this court has intervened and have passed an order. Now, when the money is in their account, that is at page 38.
No, understand something. There is a policy decision.
I have nothing to say on that. But now, right now, I'm working as an employee. They are under the obliged duty to
You
pay
are
my.
working,
Yes, ma'am.
but in order to wind up, what are the options available to the state?
They are not winding up, my lord.
This is the
Let them file an
decision.
affidavit. Let them file an affidavit and say that they want to give me compulsory retirement. Then I'm under the 136 employees who's working currently there. Let them come with an affidavit
This
that
is
they have.
what the cabinet decision says.
No, cabinet decision they have not completely implemented because I'm still working and my salary 30
Mr.
crores.
Counsel, understand the cabinet. Have you seen the
Yes,
cabinet
my lord.
decision?
But prior to this, while filing this,
You have seen it.
yes, my lord.
So the cabinet decision is that we want to wind it up.
Of course, my lord.
So
They are
there are
liberty.
these 136 people who have not opted for VRS.
Yes, my lord.
Nevertheless, we are going for winding up.
Yes, my lord.
Now, if it is for winding up, then these 136 employees, including you,
Yes, my lord.
will have to decide what you want to do. Either you wait until the day the organization stops working and is wound up,
Yes, my lord.
or you accept the offers given by the government.
The proposal for
But to
dealing-
say
My
that
lord.
your service will be continued for eternity will be contrary to the decision of the
My
policy
lord,
decision.
my humble and my respectful submission today before your lordship is that as I am a continuing employee or regular employee of this organization, and subsequently after the cabinet decision, we have moved this court and have obtained an order by getting an order that our employment shall not be, my lord, interfered with without the case being decided. That is one aspect. Now, from that order till today, I have not been paid my regular salary on the amount which is in their custody. From these documents that I have perused, my lord, have submitted clearly indicates that this amount was meant for us as employees.
Now,
who-
that will have to be examined now because if in the face of a policy decision,
My lord.
can
But
you-
currently,
can we
for last
say
11 months, my lord, they haven't received any salary, my lord.
can we say
My lord.
that in the face of the policy decision, that your claims contrary to the policy decision?
My claim is not money. My humble submission is, my lord, let them take any decision they want in respect of whether they want to keep me or they want to basically remove me. But so far as I'm working today from a period from 2024 to 25 and the amount which was
Yes,
sanctioned
what
for-
decision has been taken regarding the employees?
So the agriculture department will take decision also.
They never
Because-
taken.
because
Take, but also they are coming to work, not working.
Yeah, what
They're
coming?
coming to work
We're
because we
working.
are on the verge of closure. The board is on the verge of closure.
Let them come on affidavit, my lord.
So we'll take a decision, Lordship. We are on the board is on the verge of closure, Lordship.
That's right.
So
So,
we are, they are taking some time to wind up everything, Lordship.
so what are you going to do with these
That
employees who are
instruction I take
there?
from the department, Lordship. I am for the department, Lordship. That instruction I have to take from the
Well,
department.
you take the instruction.
But it is on the verge of closure, Lordship.
That we can see from the policy decision taken.
My lord.
cabinet decision is clear also. It was final
What is
directed at
done
agriculture.
now?
My lord, so far my only humble submission is that, my lord, from the amount which
How
is,
much time would you require to get your instructions?
they are running their
4
families, my lord, without
4 weeks.
salary.
4 weeks.
2 weeks, Lordship. 2 weeks.
My lord,
Regarding the closure of
if-
the board, Lordship, I am for the department, Lordship. He's for the agriculture
No,
board.
their claim is that whether you close, you don't close, you keep it open, it is your call.
Lordship.
But they're working.
Yes.
If they're working, they have to be paid
They have
their
to be paid.
salary.
That,
The amount has been
Yes,
sanctioned
yes.
lying in the account.
yes, yes.
You
Till
are
the date
deferring
we are
over
working,
taking-
Lordship. Till the date we are not taking a decision and they are coming to work, Lordship, they'll be getting their salaries.
Exactly, that is what my prayer is.
That instruction, Lordship, will take because in the
Yes, amount to have it. The amount, entire amounts of.
There appears to be some conflict between
If
the board
Lordship
and the
comes to
agriculture
page-
department.
page
Page
8,
eight.
Lordship, page 8.
Page 8 of what?
My instruction also.
What is there in page 8?
The cabinet decision.
That we have seen, Mr. Gogoi. That we have already seen.
Yes, Lordship, just now I came to know that the
Oh.
call is on the,
You come back and tell us on 12th. Get your instructions, what you want to do. And you come back and tell us, otherwise we are directing release of the salary.
Madam, may I just make a small prayer, my lord? If in case my learned friend is bringing the issue of closure or the policy decision, then my lord, I would humbly submit that the writ petition, the connected petition is pending, may also be my lord, tagged along with this matter, because that will be, my lord, helpful for.
First, let them get their instructions,
Yes,
what
ma'am.
they want to do.
Yes, my lord. Because there is a stay order against them.
Yes, when can you get it?
in Monday, 15 Lordship.
Hmm?
15 December.
15, this is the last week.
Last day.
You get it by 10th,
My lord.
1 week.
Regarding
10th.
the.
List this matter again on 10th, enabling the Standing Council, ASIMB and Agriculture Department to obtain instructions with regard to the status of the cabinet, implementation of the status of the cabinet decision taken towards closure or winding up of the Assam State Agriculture Marketing Board, and the fate of the employees who 136 number of employees, including the present writ petitioner, who claim to be working in the board till date. Let these instructions be placed before the court on 10th December. Get your instructions.
Okay. My lord, we have an interim order, my lord, can that may be extended?
The interim order will continue.
Yes, my lord.
It's already there, I think.
Yes, my lord. Your lordship has passed on the last occasion.
We have already said without leave of the court.
Yes, my lord.
Yes, Lordship.
Then why do you want an extension?
I'm obliged, my lord, highly obliged.
Obliged.
Okay, sir.
May I please your lordship?
Hmm.
Lordship, this impleading petition is filed for impleading the party, opposite party number 2 as party respondent number 2, lordship. The notice may go, lordship.
Which opposite party?
Yes,
Or
number two,
Council
lordship.
for Parties issue notice.
Opposite party number.
Steps on the opposite parties by registered post within 1 week from today. Matter be listed again after the returnable date.
35 months.
Right, please, your lordship. Lordship, this IA has been filed in contempt case number 148/2025 for impleading the present Commissioner and Secretary, Department of Animal Husbandry and Veterinary, that is Mr. MS Pativarnan.
Will issue notice?
Lordship.
Third Council for Parties issue notice, it doesn't do 4 weeks. Steps on the opposite party by registered post AD within 1 week from today. Mr. M. Bhagavati, Learned Council represents.
For respondent number 2 and 3.
Respondents 2 and 3 in contempt case number 148 of 2025. List again after the returnable date.
That's all.
Timing actions level.
May I please, your lordship? My lord, the petition is basically reviewed by the Indian order, that is page number 36, my lord. Here, my lord, the case of the petition is that, my lord, the earlier petition was terminated from service.
One. Even a turn. Yes.
Earlier, my lord, petition was terminated from service, but order dated, my lord, 18th of September 2023. That order was challenged before this court, my lord, and this honorable court, my lord, set aside that order, my lord, by order dated, my lord, that your lordship will find page number 32, 35, my lord. Lordship may kindly come to page number 35, my lord.
35, yes.
35. This is the order passed by this court, my lord, and page number 35, the relevant portion, para 19, my lord. That being so, the imperial termination order dated so and so is in contravention of the principle of nationalization and therefore is illegal, null and void. Resultantly, the imperial termination order dated 18/9/2023 is set aside and quashed.
Then?
After this order, my lord, I submitted a representation before the authorities that since my termination order has been set aside, my lord, so I be allowed to join my service, my lord.
Then you are allowed to join.
No. Initially, my lord, nothing was responded. Then my lord, I preferred a writ petition before this court again, my lord. That writ petition is still pending, my lord. WBC number 76 of 2025, my lord. During pendency of the writ petition, the respondent will pass this order, page number 36, my lord. Reinstating me in service, but order dated, my lord, 1st of February 2025. And by this order, my lord, the relevant portion, my lord, will find the second para from bottom. Whereas, however, Sri Bhuya would not be entitled to salary and other allowances for the period with effect from 1/6/2023 to 31/1/2025, during which he was not on duty in compliance of the principle of no pay. Now, the only issue is to be decided by this court whether the principle of no work, no pay is applicable in the case of the petitioner.
But termination was set aside.
Set aside, my lord. Now, the question is here, petitioner was terminated from service on 18th of September 2023, in the month of September. Now, they are saying that I am not entitled to the salary, my lord, since the month of June, my lord, when I was in service, my lord. And secondly, on the same day, my lord, initially, my lord, actually, they are questioning the procedure of my appointment. That is a different issue, my lord. For that, my lord, again, I want.
No, it will issue notice now. Why? This is what? Item number? Okay. We'll issue notice here.
My lord.
Right, Learning Council for the parties issue notice. Mr. C.K.S. Borua.
All respondents.
Government Advocate appears and accepts notice on behalf of
All respondents.
respondents, all the respondents.
All respondents.
And therefore, notices are waived. Extra copies be furnished within a period of 1 week from today. Respondents may complete their instructions and file the affidavit if so advised.
Two more writ petition of the same petition against the same respondent are pending before this court. So this matter also may be tagged with those writ petition and be listed on the same.
Be listed.
WBC number 76 2025.
Date. It is submitted that writ petitioner has filed 2 other writ petitions. For what purpose?
The earlier writ petition was filed for reinstatement of the petition in service, and
that is already done.
Done.
So that has to be closed.
That will have to be closed.
Yes.
Secondly, my lord, on the very same day, my lord, on the day of reinstatement, they have passed another order suspending me from service, my lord, with effect from the same date, my lord, from the
You
date
are
of
now
the-
suspended.
Suspended. Now, since I have been under suspension, they should pay the subsistence allowance. They are not paying the subsistence allowance. So for that, my lord, claiming the subsistence allowance,
They are
I
not
have
connected, they are separate matters. No.
Separate pairs.
pairs are
Very
separate.
For the petitioner submits that although the petitioner was reinstated in service by the order dated
1/2/2025.
1/2/2025, on the same day, another order was issued whereby the petitioner was placed under suspension.
Suspended. That order you also will find page number, my lord, page number 40, my lord.
Which is enclosed as annexure 14, the present writ petition. Stop. This order has been challenged by filing a separate writ petition being WPC number
6032
6032
2025, man.
2025.
Yes.
It is submitted before the court by the counsel for the petitioner that both these writ petitions be listed together.
Yes.
Accordingly, let this writ petition be listed along with WPC so and so.
76/2025 and 6032.
So 76 has become infractuous. Why do you want to list it?
No, but on the same, ultimately, an analogous matter, and the, this matter is
along with
pending.
WPC so and so list. Yes.
Hello.
Extra copies will be given to.
Extra copies will be funded.
I'm giving the list of WBC number.
Supplemental list for admission item 37.
My lord, there is some development, my lord. My lord, on the issue of petitioner service and his service benefit, I have brought on additional affidavit, my lord. On that, your lordship may dispose of page 99, my last page of my additional affidavit, my lord. The principal secretary department has sent it to the principal secretary, concerned principal secretary of Dima Hassan, my lord, to take a decision, my lord, on the service and service benefit. On that, your lordship may direct them to take a decision, my lord.
What is your claim in the writ petition?
Claim was, my lord, to review the, my lord, the order of dismissal after acquittal in the criminal case, honorary acquittal, my lord.
Where is that order of dismissal?
Dismissal, my lord, page 44, my lord.
44.
Yes, my lord. Then, my lord, acquittal, my lord, judgment, page 45, my lord.
This dismissal is pursuant to an inquiry conducted.
Pursuant to an ex parte inquiry, my lord. But-
Then was an appeal filed?
No, madam, because
appeal filed.
no sustenance allowance was paid to him, so he could not appear, my lord. And that time there was some, my lord, outfit problem, my lord, ban outfit problem. Now the thing is, my lord, now, my lord, presently, after filing of the writ petition, my lord, the department on its own, my lord, has communicated by the water resource chief engineer, my lord, to the principal secretary to review the dismissal order on the basis of the, my lord, order of acquittal passed by the judicial magistrate. Page 99, last page of my additional affidavit. So my submission, my lord, this writ petition may not be taken into own merit, my lord. Let the department
Yes,
within a time
Mr.
frame.
Das.
Lordship, as per the telephonic instructions which I have received from the concerned executive engineer, Dima Hassau, he has sought some time, since it's an old matter, he is not able to
No,
track
no.
the.
His prayer is that
Yes.
in view of this page 99,
Yes, Lordship.
addressed to the principal secretary, the writ petition should be closed.
Yes, Lordship.
Let a decision be taken within time frame.
All right, heard counsel for parties. The writ petition is filed by the petitioner, putting a challenge to the order of dismissal. The writ petitioner from services. Where is the order of dismissal?
Page 44, my lord. By the concerned principal.
By pursuant to an inquiry instituted, the Principal Secretary, Dima Hassau Autonomous Council, by order dated 7th of July 2013, accepted the findings arrived at by the inquiry officer and dismissed the petitioner from service, and also directed recovery of the missing / misappropriated government money from the writ petitioner. So criminal cases were also instituted against the writ petitioner. So the writ petitioner has assailed this order of dismissal on the ground that the inquiry was conducted ex parte and no opportunity was granted to the writ petitioner, and he could not afford to appear before the authorities as
No subsistence allowance.
no subsistence allowance was paid to the petitioner during the period of suspension pending the inquiry proceedings. Stop. Subsequently, the Criminal Court of Competent Jurisdiction by judgment dated
Page 45.
19/9/2024, passed in Haflong PS case number 82 of 2013.
Presently, PRC case.
Competent court nalage, Court of Additional CJM Dima Hassau. Acquitted the petitioner and another of the charges. Stop. They were set forth at liberty. And bail bond, bail bond was discharged. Bail bond was also discharged. Pursuant to the acquittal, the writ petitioner, the deputy chief engineer, the deputy chief engineer, Water Resources Department has communicated on 21/5/2025 to the Principal Secretary, Dimahasa Autonomous Council for taking necessary action in the matter. But there is, okay, regarding review. Yes. But it is not there in the communication dated of the principal secretary. It is there in the executive engineer.
My lord, there is two letter, my lord, page 98 also.
So 98 is for review. But in the letter which you are referring to, there is no mention of review.
Subject, my lord, regarding dismissal of service, that is, they will review as per the GR case, my lord, legislate, passed by judicial magistrate.
Stop. According to the writ petitioner, by these communications, the Water Resources Department authorities has requested the Principal Secretary, Dimahasa Autonomous Council, Hapong, for review of the order passed by the disciplinary authority dismissing the petitioner from service, as the petitioner was acquitted in the criminal case being
Those by department.
so and so case, TRC case number so and so. Pero, these communications are brought on record by filing an additional affidavit. Stop. It is the submission of the counsel to the petitioner that at this stage, the writ petition can be closed with a direction to the Principal Secretary, Dimahasa, to examine the matter and pass appropriate orders on the prayer seeking review of the departmental proceedings, leading to dismissal of the writ petition. Stop. But there has to be a powerful review.
Yes.
Where is that powerful review?
But that decision has been taken by department itself, my lord.
How?
On the basis of this order passed by.
The counsel for the petitioner therefore submits that at this stage, the writ petition be closed, permitting the department to examine the matter and pass appropriate orders. Stop. The prayer made is not disputed by the counsel appearing for the respondents. Mr. Avindas. Stop considering the prayer made. This court is of the view that the writ petition be closed without expressing anything on merit, enabling the respondent department to examine the matter and pass appropriate orders if permitted in law. Writ petition stands disposed. Interim order any stand vacated. The matter be examined and appropriate orders be passed thereon within a period of 90 days from the date of receipt of a certified copy of this order. Mr. D. Bora for
1.
Respondent 1.
38.
Obligation.
May it please your lordship. Lordship, matter may taken up next week, lordship.
Next week.
Yes, lordship. My senior is out of station and respondent authority not filed an affidavit, lordship.
Huh?
Respondent authority not filed an affidavit, lordship.
Prayer is made on behalf of the counsel for the petitioner seeking an adjournment today. None represents the respondents also. Accordingly, let this matter be listed again on 12th.
Chief interim is there.
Interim order passed earlier will continue.
Okay.
12th December.
May it please your lordship. Lord, we filed an IA, my lord. In the writ petition cost title, my lord, there is inadvertent error, my lord, with regard to the designation of the petitioners, my lord. It ought to have been, my lord, assistant executive engineers, my lord, but we have wrongly put it as assistant engineer. And consequently,
For the petitioners.
petitioners, my lord, the designation is assistant executive engineer, and we have wrongly put it.
Any objection, Mr. Lord?
Consequently, my lord, in the order dated 25/9/2025, my lord, the same, my lord, mistake happened, my lord. Our fault, my lord.
Third counsel for parties, this IA has been filed, IA, seeking correction, seeking modification, alteration of the post title in WPC 3457 of 2025, as also in the order dated 25/9/2025, passed in the same writ quotation stop. The counsel for the applicant submits that by oversight, the names, the designation of the writ petitioners were shown in the writ petition as assistant engineers, when they are actually serving as assistant executive engineer.
My lordship.
Civil.
My lordship.
Stop. The same error also occurred in the order dated 25/9/2025, passed in WPC so and so. The IA has been filed seeking liberty of the court to amend the course title, and also a further direction that necessary corrections be incorporated, be read, necessary corrections incorporated, be read in the order dated so and so, passed in WPC so and so. Mr. Dhor, learned R. Dhor, learned standing counsel for the opposite party department, does not object to the prayer made. That view of the matter, the IA stands allowed. Petitioner, the writ petitioner's designation will now read as assistant executive engineer instead of assistant engineer. Assistant executive engineer civil.
Civil.
In their respective divisions, Borpeta, when someone is in Mulberry, instead of assistant engineer, as was earlier reflected in the writ petition. Stop. The amended course title be filed in the matter within 1 week from today. Stop. Similarly, in the order dated 25/9/2025, passing 3457 of 2025, the designation of the petitioners are to be read as assistant executive engineer instead of assistant engineer. So this order shall be read together with Why are you correcting this order? It doesn't reflect anything here.
Page 10, my lord.
Oh, in the course title of the order.
Course title of the order.
Not in the body.
No.
The same shall be read. Same shall be read to be assistant executive engineer.
Civil.
Civil. In so and so division for petitioner number 1 and so division for petitioner number 2. And what about 3?
3, my lord.
And so division for petitioner number 3. Also in the order dated so and so, passed in WPC 3457 of 2025. Stop. This order shall be read together with the order dated so and so passed in WPC so and so. IA accordingly stands allowed disposed of.
Deeply obliged.
In the writ petition, you write in view of the order passed today in IA number so and so. The petitioners are permitted to file amended course title reflecting the correct designation of the writ petitioners, i.e. Assistant Executive Engineer Civil so and so district in respect of respondent 1 and 3 in place of
Assistant
Engineer Civil as was earlier done in respect of petitioners 1, 2 and 3.
Deeply obliged.
Disposed.
My lord, a private respondent has filed the affidavit in opposition, my lord. We'd like to file the reply.
Counsel for the petitioner submits, so the private respondent has filed an additional affidavit in opposition to which the petitioner would like to file the reply affidavit.
After winter vacation, my lord, immediately.
In matter, he prays for 4 weeks' time. Mr. S. Doctor appears for Panchayat Department and Mr. Izaman for respondent number 7. List again after the returnable date.
Obliged.
You're blessed. Hmm?
For hearing, I think 41.
May pillars 1. I'll have to take a lawsuit through the page 19 onwards. Again. Because here, my lord,
Judgment Ruta issue reporter.
page 19 was the FIR again.
No, we have gone through all that.
No, what is my
The
lord?
thing that we want to know is.
No. They are
Also
relying.
place a judgment regarding the presenting of.
That only my one submission.
Ah.
The foundational fact of the case in the department proceeding here is the based on the FIR primarily. So that is the foundational fact. And my lord, what is foundational fact and what is my lord educative evidence that Black's Law Dictionary brought. So once they base the entire proceeding on the FIR and every witness said there was a rape. Of course, they were not direct evidence. They were officials, my lord. They said the whosoever appeared. They said simply there was there. They didn't know anything about the facts. Only relevant witness one produced was that sister-in-law. So she said there was a rape. The girl was not examined.
Examined. Statements were taken.
Victim exam.
Yes.
In the proceeding.
Yes.
Okay. And the foundation fact, if the FIR is there, FIR was not exhibited. And my lord,
Mr. Counsel, this is not a criminal proceeding.
yes, my lord, but if
Unless you say, unless you show us some authority to say that in matters like this, when the matter is in the trial, and nothing is, as on date, the trial is not complete, departmental proceedings cannot proceed.
yes.
Then show us some authority on that.
No, that is an answer. The department also cannot proceed until the proceeding.
The departmental authority has proceeded, all the witnesses, their statements have been recorded, they have stated whatever they have stated. Petitioners, the department's stand is that the petitioner was given opportunity, did not proceed.
My
You
lord,
say that no,
on that
no
also I'll come, my
opportunity
lord.
was granted.
Your lordship see the inquiry report. Your lordship will see the inquiry report. Just a minute.
Mr. Sutia, what we propose to do is we want to remand the matter back to the appellate authority. The reason being.
That can be, my lord, yes.
Reason being that the that the petitioner has taken, in the appeal, has taken a ground specifically that he was not given an opportunity to be examined. That has not been answered by the appellate authority.
Appellate authority, my lord. My lord, whatever they are arguing, my lord, they're not based on the pleadings. I will place reliance of the honorable court if the pleadings is not based on the prayer, my lord. Prayer petition is not based on the pleadings. He cannot argue this case. Last occasion, he said that list of debt is not provided.
All these are gone. Only thing is that in the appeal, there is a specific ground urged that they were this paragraph number 4. Her statements were not recorded in the presence of the appellant. These witnesses submitted not in the presence. The appellant was not provided an opportunity to cross-examine. This is a specific ground they have taken. Whether urged or not, we don't know, but the appellate authority did not deal with this aspect. Because this will require examination of the records, if required, examination of the various evidences, whatever is there, and let the appellate authority pass specific orders on that.
His only specific question is that is the order not given reasonable opportunity.
That's
In
right.
the whole petition and his appeal memo, I have gone through it, but there is nothing, my lord, mentioned about anything that list of debt is not provided to move, list of witnesses are not examined like that. In the appeal memo, petitioner to where stated that he was not provided list of documents and name of witnesses. Only in the paragraph 4 stated he was not given opportunity to cross-examine those 4 number of PWD. In case he put his signature, he denied it. Non-providing list of documents and name of witnesses and not providing opportunity to cross-examine them is prejudice caused to the petitioner. He no way stated that not providing it, he says there is a prejudice to him to defend the case. No way stated, but I have gone through the writ petition and also his appeal memo. That's why I'm saying, my lord, what is they are arguing, that is beyond pleadings. And in the appeal memo, he has narrated what has stated inquiry report was provided to him. He said, he admitted it. His statement only that as per medical report, he only said as per medical report, there is no injury mark in the private victim of 11 years old. That was a false case. It is not a rape case. The only that mark he stated in all the paragraphs of the writ petition. And also his appeal memo is the same, reflected from the application. I have gone through it. If that be yours also, they are saying not giving the list of debt. List of debt I have seen here, nothing else, only the communication WT message. Had it been provided, suppose he has not received, had it been provided, what would be the answer? Only WT message, so and so is absent, so and so is not here, so is file a case. They are list of the document in show cause notice. And that is, nowhere in pleading says that due to non-providing of the so and so, there is he cause prejudice to him to defend his case. Nowhere. That's why I rely upon the 3 cases, if there is not founded on the
Where is the judgment of the presenting officer must be provided?
That I could look at my
They are
but
to not
one
taking this
important,
also,
just,
please.
if you bears with me, one important thing, when the inquiry report is given, then I file the WS objection against that. In that, my lord, the authority, this authority, appellate authority, did not consider my statement in the inquiry, my lord, page 31, you also kindly see. Page 31.
No, inquiry officer is to, this is just to give you an opportunity.
No, opportunity, but that aspect must be considered by
Page
the,
31 is a part of the inquiry
yes,
report.
what I have said, my statement. Because I didn't cross-examine anybody, but my statement must be considered by them while passing order.
Where is your statement?
Page 31, PW6. I haven't made page 6. Actually, I was the accused. He stated that he was performing duties so after completion. So now he'll also kindly come to last line. He knows that the One namely, Omar Ali lodged an FIR at Boygaon PS against him. The
He stated that.
he stated that few days prior to the incident, a verbal argument took place between him and the Omar Ali due to non-receive the house rent and the of his rented house, and it threatened him. Then thereafter he was arrested and forwarded to judicial custody. So, my lord, this aspect, this is important aspect, my dear. Why that was considered? Because it is not empty formality, my lord, that the submission made by me, WS filed by me against the inquiry report must receive the consideration by the authority before passing the my lord, impugn order or dismissal. And punishment is very harsh.
This is again not pleaded in your appellate.
But my lord, it is a part of the record, their own official record. I may not plead, my lord. What is in the record? That is the truth. Even the FIR was not exhibited.
Where is your reply to the show cause before the order of punishment being imposed was passed? Where is your reply to that?
Only reply says, Ballot, medical report says there is no injury in the part of
No,
Ballot.
no, many things he said, not only that.
Nothing, it says, show me.
Page 39.
No, no, no,
I'll
no,
show,
the
I'll
pleading.
show this
Yes.
inquiry report. Page 39, my lord. We have enclosed the medical report also, the FIR also here. Whether they have considered that my part of this important reply to the inquiry report.
Paragraph.
I've also said about
Reply,
the
page
doctor who
39.
examined the
Page
victim.
39. Page 39.
Page 40.
Oh, 40.
The doctor who examined the victim at the time had already examined by the Honorable Special Judge Boygaon, and he found no injury mark on the private parts of the victim, and hymen of the victim found in.
Nice one.
Okay, sister.
Her informant, victim is a nice of the
Sister-in-law.
people.
Sister.
Not
Sister-in-law.
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 Committed rape in his house on so and so date. Stop. In the FIR, it was alleged that the petitioner had called her sister-in-law of the informant, to his house on the pretext of cleaning utensils. And when she reached the house of the informant, she was raped, forcibly raped. Stop. This FIR was registered as Bongaigaon PS case number 550 of 2019 under section 4 of the POCSO Act. Stop. The petitioner was arrested on 1/8/2018, and thereafter he was placed under suspension pending Royal of Departmental proceedings. Stop. Petitioner was subsequently enlarged on bail. Stop. Thereafter, the departmental authorities issued show cause notice dated 13/11/2019, charging the petitioner with gross immoral conduct, indisciplined act, and dereliction of duty. Stop. Petitioner submitted his reply to the show cause notice. Stop. Being dissatisfied, the departmental authorities appointed an inquiry officer to proceed with the departmental proceedings. Departmental inquiry to examine whether the charges made against the petitioner by the show cause notice to inquire into the charges made against the petitioner by the show cause notice, and whether imposition of punishment under Rule 7 is or is required. Stop. The inquiry officer appointed completed the inquiry report and concluded that the charges against the writ petitioner have been proved. And the same was submitted to the disciplinary authority. So the disciplinary authority by notice dated 11/6/2022 issued a second show cause notice on the writ petitioner upon receipt of the inquiry report. Stop. Petitioner was called upon to submit his reply, if any. Within 15 days from the date of receipt of the communication. Stop. Petitioner filed another reply dated 25th of June 2022.
Reply file 25th June 2022.
There I have taken the grounds.
Attempting to persuade the disciplinary authority not to impose punishment as contemplated. Stop. Thereafter, by order dated 4th of July 2022, the impugned order of termination was issued. The petitioner was dismissed from service with immediate effect as per Rule 7 within bracket Roman 7 of the Assam Services Discipline and Appeal Rules 1964 for his gross immoral conduct, indisciplined act, and dereliction of duty. Stop. An appeal under Rule 66 within bracket V of the Assam Police Manual was filed before the appellate authority, namely the Deputy Inspector General of Police Assam. So, in the appeal also came to be rejected by the appellate authority by the order dated 7/10/2022, whereby the order passed by the disciplinary authority was upheld. Stop being agreed, the present writ petition has been filed. Learned counsel for the petitioner strenuously urges before the court that the entire process, entire departmental proceedings initiated against the writ petitioner was based on the FIR which was lodged against the writ petitioner and the statements of the witnesses recorded by the investigating authority. Stop. It is submitted that the allegation made against the petitioner is a very serious allegation under Section 4 of the POCSO Act 2012. Stop. The matter is presently under trial, and the trial court has not yet delivered the judgment, either convicting or acquitting the writ petitioner. Stop. He therefore submits that the allegation made against the petitioner is subject to such proof as may be arrived at during the trial by the trial court. Stop. As on date, they are mere allegations and the petitioner has not been convicted. Stop. Therefore, to base, to have the entire departmental proceedings be initiated only on the FIR and the statements made or recorded by the investigating authority is wholly incorrect and contrary to the rules of criminal jurisprudence. Stop. The learned senior counsel submits that there is no other material on the
One
basis
more
of
thing,
which
May I intervene?
the inquiry was conducted. And the charges have been held to be proved by the inquiry officer, save and except the FIR and the statements made before the investigating authority in connection with Bongaigaon PS case number 550 of 2019 under section 4 of the POCSO Act of 2012. So, yes.
I have also asked my lord, violation of national justice, my lord, that the statement given by the witnesses ought to have been furnished to me as well as the secondary evidence given, because then only I could file the.
This is not secondary evidence. They have not recorded it properly. It's not secondary.
Whatever it is, my lord, they should, whatever they have recorded, my lord, they should be.
It is the-
There is a violation, my lord, for me, there is a violation of national justice.
Oh, there is no pleadings at all.
No need to believe. National
The-
justice did not pay pleaded.
Pleadings is-
This is your record will say.
Submits that the entire proceedings were conducted in complete violation of the rules of natural justice, as the relevant statements, as the witnesses were not examined by the inquiry officer and mayor's statements were examined, and that too, the same were not furnished to the red petitioner, giving him an opportunity to rebut the same. Stop. He therefore submits that the inquiry proceedings being contrary to law, the same should be interfered with and set aside. And the order passed by the disciplinary authority, having disciplinary authority dated so and so, and the appellate authority dated so and so, having failed to take note of these deficiencies in the inquiry, are also required to be interfered with and set aside. Stop.
My lord, would it be necessary, my lord, the judgment to relied here? Because we given there.
You give us the list.
Yes.
Learned counsel in support of his contention, please rely on the following judgments. Para, listed PC Sukia, additional senior government advocate, assisted by MS P. Devi. Strongly disputes the contentions raised by the writ petitioner. It is submitted that the departmental proceedings have been conducted by following the procedure prescribed under the Assam Discipline and Appeal Rules, 1964, read with the Police Act and the rules. Stop. It is submitted that the list of witnesses and the documents enclosed to the show cause notice was duly furnished to the writ petitioner along with the show cause notice. And therefore, there cannot be there cannot be contention raised. There cannot be the contention raised cannot be accepted that the proceedings were conducted in conflict with the rules of natural justice and of legal or the procedure prescribed under the rules of 1964. So the learned additional senior government further submits that from the inquiry report, it is evident that The petitioner was given opportunity, but he declined to avail the said opportunity to cross-examine witnesses. Therefore, at this stage, to turn around and assail the proceedings on the ground of being violative of natural justice would not be available to the writ petition. Stop. He further submits that on the facts which are pleaded before this court, the only ground assailed before the writ court is that the proceedings have commenced in violation of natural justice and no opportunity was given, and which, on a bare perusal of the inquiry report, reflects that the same is incorrect. Rather, the petitioner declined to cross-examine and maintained that he had nothing to say, as he had already given his statement to the inquiry officer. Stop. In support of his contentions, the learned counsel has referred to the following judgments. Stop. Para learned counsel for the parties have been heard, pleadings available on record have been carefully perused. The records called for from the department were also produced and have been carefully examined. So, the facts which led to the departmental proceedings are not in dispute. While the petitioner was serving as a constable in so-and-so outpost on the so-and-so police station, an FIR was lodged by the complainant so-and-so, which came to be registered as Bongaigaon PS case number so-and-so under section 4 of the POCSO Act. Stop. The petitioner was subsequently arrested, but the petitioner was thereafter arrested and subsequently released on bail. Stop. As is required, as is mandated under the rules of 1964, if a government servant is detained in custody for more than 48 hours, the department is to initiate departmental proceedings to inquire into the reasons for his detention beyond 48 hours. Stopped. Consequently, a show cause notice was issued, leveling the charges against the writ petitioner. Stop. The show cause notice was is shown to be, it was enclosed, had enclosed the list of witnesses and the documents to be relied upon. Stop. The charges alleged, the charges made in the show cause notice were duly replied to by the petitioner denying the charges. Stop. Thereafter, inquiry officer was appointed and the matter proceeded before the inquiry officer. Stop. Before this court, no material has been placed to show that the writ petitioner raised objections with regard to the opportunity not being granted to verify or examine the documents relied upon by the department, end of legal or lack of opportunity to examine the witnesses, or even disputing that the proceedings cannot be initiated on the basis of the statements made by the informant and the witnesses, which were recorded by the investigating authority. Stop. However, the inquiry proceeded, and by order dated so and so, the inquiry officer concluded that the charges leveled against the petitioner has been held to be, has been found to be on the basis of the charges leveled against the writ petitioner, the petitioner has been found to have indulged in gross misconduct. Stop. This was subsequently submitted to the disciplinary authority, who again issued a show cause notice, to which the petitioner also replied, denying the allegations leveled against him in the inquiry report. Stop. However, the authorities declined to accept the contentions of the writ petitioner, and by order dated so and so, the disciplinary authority imposed the punishment of dismissal from service under Rule 7, within bracket Roman 7 of the Rules of 1964. Stop. The petitioner preferred an appeal before the appellate authority, which also came to be dismissed. Better. From the pleadings, from the submissions made before this court, as well as the pleadings available before this court, it is seen that the primary ground urged before this court is the violation of rules of natural justice. The petitioner has maintained that he was not given sufficient opportunity to
defend his
case, or by examining or cross-examining the witnesses, nor were the documents which were relied upon confronted to the writ petitioner. Stop. Although from the records, it is not seen that such objections were filed before the concerned authority by the petitioner. Although from the writ petition, no reference is seen in respect of any such objection being filed before the petitioner, before the department, Oman. In the appeal memo filed before the authorities, there is a specific ground taken by the writ petitioner So the writ petitioner in ground number 4 has urged before the appellate authority as under page number 50, ground 4, extract corridor. But to this court, it appears that the petitioner has ventilated his grievance of not being granted any opportunity to cross-examine the witnesses before the appellate authority. Stop. However, upon a careful perusal of the order passed by the appellate authority, it is seen that the appellate authority did not address these grounds specifically, and no finding to that effect is seen in the order dated so and so passed by the appellate authority. There is a finding in the recital of the order that the appellate petition as well as the DP file has been scrutinized by the appellate authority. So, however, there is no such finding by the appellate authority that the grounds urged by the writ petitioner in respect of violation of natural justice by preventing him from examining or cross-examining the witnesses is not a valid ground, as was evident to the appellate authority upon examination of the records. Stop. In the absence of such finding by the appellate authority, the grievance of the writ petitioner that the opportunity of cross-examining the witnesses raised before the appellate authority remains unanswered. Stop. According to this court, the appellate authority was empowered to return a finding on these grounds urged. Stop. Absence of any specific finding and closing and disposing of the appeal filed by the petitioner by an omnibus conclusion that the proceedings, that the inquiry officer during the proceedings had given ample opportunity, will not or cannot be considered to be effective consideration of the grievances urged by the writ petitioner in the appeal hearing. Better. In so-and-so versus so-and-so, the apex court has held that the appellate authority must give reasons while disposing of the appeal. It was held that the appellate authority must give reasons in the appellate order so as to enable the writ court to ascertain whether there was any application of mind to the points urged before the appellate authority. It was a duty of the appellate authority to give reasons and end of legal record reasons thereof. Stop. The appellate authority is required to examine the charge, examine the conclusions arrived at by the inquiry officer as well as by the disciplinary authority as to whether the evidence adduced before the inquiry officer had nexus to the charges leveled against the writ petition. Stop. The power vested on the disciplinary authority is equally available to the appellate authority. Stop. If the appellate authority was of the view that the adequate opportunity was not granted, then they are within their, then there are ample powers to interfere with the orders passed by the disciplinary authority by passing appropriate orders. Stop. Even at the point, even while they're confirming the conclusions arrived at by the disciplinary authority, it was incumbent on the appellate authority to conclude, to give sufficient reasons while confirming the conclusions arrived at by the disciplinary authority imposing the punishment. Stop. Better. These reasons, the impugned order passed by the appellate authority do not contain the adequate reasons according to the opinion of this court. Stop. Therefore, considering the matter in its entirety, the writ petition is allowed in part by interfering with the impugned order that 7/10/2022 passed by the appellate authority Stop. The matter is remanded back to the appellate authority to redecide the matter afresh and pass appropriate orders by examining the matter in detail. Stop. The reasons must disclose as to whether the petitioner was granted adequate opportunity to examine or cross-examine the witnesses, and whether the statement and oblique or the examination of the witnesses by the departmental authority was undertaken during the departmental proceedings and in the presence of the writ petitioner. Stop. The writ petition accordingly disposed of in terms of the above. The appellate authority is expected to pass appropriate orders as expeditiously as possible within a period of
1 month. Earlier also it was 1 month.
Within period of my lord, 2 months, my lord.
Earlier also this court has given 1 month only.
1 month.
Yes.
Let it be 60 days.
60 days after receipt of the certificate
60
copy.
days from
Or
the
receipt
date of
of-
receipt of a certified copy of
Copy of
this
the
order. Since the order is passed in the presence of the counsel for the parties, no further notice is required to be issued to the writ
Only one
petitioner.
thing, my lord, the grounds I asked.
Will appear before the appellate authority by submitting a copy of the certified copy of this order. Stop. If the petitioner makes any application for filing additional grounds, the same shall be considered by the appellate authority as per procedure prescribed.
Obliging.